Okay, trial docket. Any pleas off the trial docket, or is it business as usual? Do we have any pleas off this docket? No?
But some that are in the process of working them out.
Okay.
And
Well,
the very first one, Darius Stevens,
yeah,
he's got a murder case in Orange, and we're just going to try to release him to go over there to get rid of his murder case, because that's going to be dispositive of these others.
is that right?
That's good.
Well,
It's an old murder case, so it's gonna go fast over there, Judge. I am representing him over.
is it really gonna go,
Yes, sir.
over there?
Yes, sir.
So Stevenson can be reset.
But we just need to make sure that if you could release the hold on him, Judge, there is a bench warrant that has been issued by Orange County. The 163rd, no, the 260th court. If you could release the hold, I'll Lacey release it so we can be over there this week.
Okay. Okay. I'm just a little fuzzy about what they're doing over there, and so where is the definitive? Is he over here?
He's
Is
here.
he over
He's here in
there?
jail.
Or is he in Vidor somewhere, halfway in between?
He's here in jail in our county, and
Because this whole thing, almost nonsensical. Nothing gets done when everybody's grabbing holds on each other, right? I mean, it's always good.
Yes, sir,
to
but
things out.
in Orange, their case is really strong, and so I think that's going to be dispositive of all the ones I have.
Yeah,
Okay.
that's great.
Yeah.
Yeah, if that really is what ends up happening. But Stevenson is reset, and then you want me to release a hold on him? Is that right?
That's correct.
All right. Yeah. He doesn't bond out and then leave town.
No, sir.
Derek Lewis is Mr. Kindler is always the first one here, and I'm surprised he's not here tonight.
State's ready on that, too.
Yeah, you sir, or Mr. Lewis?
Yes, sir.
Yeah, is that right?
Yes.
Have you even seen your attorney today? When was the last time you even said hello to him?
Maybe about a month ago.
Month ago. And you're set for trial today, and y'all hadn't talked in a month. Not your fault. It's not your fault. Xavier Senegal, Joe Vasquez. Yeah. I
I said hello to Mr. Senegal Saturday. He'll meet you halfway. Judge, I'm asking for 30 days to get some phone records that Mr. Senegal thinks would be very helpful. I haven't.
So it's 1,200 days. Oh my God. And now we're doing something?
We came
On
up,
the day
I
of the-
believe, a while back, like about 3 weeks ago, but Mr. Vasquez got in trial in that murder case with us.
I know, but that was just 2 or 3 weeks ago.
Yes, sir.
This is going on 1,200 days old, and now we're doing some discovery.
First I learned of the carrier.
What do you mean?
First I learned of this. What do you want on a person case?
Well, what else is he going to want?
I think this is the last.
You think?
Case.
No, it's at 1,200 days. I'm not giving that time. Oh God, no. Yeah. No, where is he on bond or
No, sir,
something?
he's
Okay, well, that's,
he has a 4-year offer and he's been in jail for 3 years. He's just adamant that these records will.
okay.
Hello, I'm on second, this was just the one in the room.
He's not grievances. It's not the reason. We're on the same page in there.
Okay. I mean, is it one enhancement from the third to the
Yes, sir.
second?
Yes, right.
Okay, well. What's state say on this? I mean, it's doing what they do it's just working his time out, in county. Well, what do we do about that? There's a motion to withdraw here that you filed as well. Did you withdrew that?
No, sir, he filed a grievance. I filed a motion to withdraw.
What about that?
Well, I don't think the court's ruled.
Are you asking me to do that? Or you? Okay. I'm pulling it out of you, Joel. I mean, you gotta, just filing a motion doesn't get it, you know, you gotta present it somehow. Sir,
We've discussed it, I thought about a year ago.
January, sir,
Oh, there may be.
January 13th is when it's filed.
It might be
Okay.
the second.
Yeah. Listen, what was the reason? What was the reason they're
Breakdown in community.
unable to effectively communicate? Well, if that were the reason, everybody would be withdrawn. Well, y'all both speak English. Let's just communicate. Right? So are y'all ready otherwise?
Other than the
Stay?
Yes, sir.
Okay, then let's try this thing. Cortez Zachary. Fine.
Ready here.
Which one? There's, it will be what? Let's see, 2, 4, 6, 8. There's 9 cases. Which one? Okay. Is backup on this, Zachary? Do y'all have do you have a backup case to file? Y'all ready? Like on one of the controlled substances cases too? Because of the nature of the case, you know what I'm saying? It's family violence.
Oh, no, we have our victim,
Mhm.
ready to go.
Okay. Well, okay. Sometimes that changes, you know. I just wondered if you had a backup on one of the controlled substances cases if that failed.
No, sir, I think this one, he's habitual to resolve everything.
I know.
She's very cooperative, so you
But
back.
that's the key. That person's the key.
Yes, sir.
Uh-huh. The other ones are habitual. There's a cocaine case, right? That's an habitual, a second degree that's habitual as well. I was just curious if you had a backup plan in the event, you know, the be prepared motto, Boy Scouts. It, 476. Deshaun Barlow, Marvin, on those. I love it. 40 cases, no pleas. 40.
Some of them are in the process. It's taking a while for some
Yeah,
things.
they're all
Okay, on Mr. Barlow,
over. On Barlow.
my investigators, there's 2 shooters involved in this. My investigators went out and took a statement from
What do you
him.
want to do today?
We just need to reset it 4 to 6 weeks to see if I can check out what he told us. I
Is
think.
that right?
That's right.
You said Kevin, go fast. Mr. Grove is not here. Kevin Gilfay is in jail. Christopher Keller, Mr. Bank. Tom?
Yes, sir.
Yeah, Chris Keller. Christopher Keller.
I was in the trial 2 weeks ago in shooter.
So was I.
I thought I saw you there. He wants a trial judge.
Judge, I need to remind you about something. We had
Okay,
previously had a bond hearing on this case, and you had told him if he wasn't gonna get reached this week, that you were gonna revisit his bond. I just wanted to remind you of that.
what's the reason I'm not reaching him this week?
I thought it was,
Especially said this.
yeah, I thought it was special.
Whatever you want to do, Judge.
Okay, then especially set, right?
Yes.
Y'all ready?
Yes,
That
Okay.
weeks ago.
Then that's one. We'll do that one. Okay. Troy Chief,
We're ready on that one, Judge.
two. Willie Dumas,
Who's ready? We're ready. We moved our.
three.
Don't want to do that.
That from person. Who's the victim on this? A relation?
No.
No, stranger?
Yeah. Yes.
Okay.
Mr. Dennis.
Yes, yeah.
What time do you need me back there? 1 o'clock, 1:15.
15.
That'd be excused early.
Yes. Jerome Marks,
But he didn't give anybody.
Mr. Wilkerson,
I haven't seen the judge.
Mr. Wilkerson. You must be riding with a couple of the others. Or not. Malcolm Hammond, Todd LeBlanc.
He was the guy.
Yeah, and this you wanted last week that he had a meeting in another court this morning, so. And
And a murder case in another court. I wonder. Alfred Washington, Mr. Wilkerson again, Jerome Ned.
Yes, sir. Some older people pointed out what older people talking about.
All right, Charles McDaniel. That's Matuska. And Brian, shoot, hello.
I was gonna say, I think there's something.
I'm still waiting on some, there's some, phone dump, Your Honor.
Y'all know it's on the trial docket,
Yeah.
right? Everybody, okay, y'all were here because of that. All right, but it's 215 days. I don't expect, never tried one like that, 215. But what do you want to do? Steve.
Well, Your Honor,
We gotta
I
move
would ask to
forward.
have it reset, to ensure that Mr. Matuska has access to all.
Is that what you want? You're the defense?
Yes, Your Honor.
We're still collecting some of the evidence.
Yes.
Communicate here.
Communicate with Mr. McDaniels as one that. So we have to be confused.
Where's McDaniel?
jail.
He's in jail? He is. All right, it's resent. Zarate, Prose. David Zarate. Sarah, stop.
Yes, Ron.
That's, y'all ready on Zarate? Okay. All right, let's see. Got Christopher Keller as one, Cheek is two, Dumas three. How's that? And who is on Cortez Zachary for the district attorney for the prosecutor? Daniel? Okay. Oh, those. And then, gonna. On the Derek Lewis, Jimmy, y'all are ready on that?
I'm ready, Judge.
Okay, that'll be 4. Senegal's 5. Okay. Here's all of those. Absolutely nothing. Nothing gets done on that. Nothing. Go back. Go back 2 years. Here.
Here's the next one, Judge,
Do what?
the next one.
Yeah. Let's see. How about, Glover Jones?
Question on,
Yeah, it is.
you, Glover Jones.
Yeah, 25 CR 291, please.
Make sure you got there on this. Glover Jones,
Does he have a,
Glover Jones.
is he,
Shouldn't he be in custody?
yeah, isn't he in custody? It says a parole hold. I can't imagine he's out there pampling about. He's what?
No.
He's got a parole hold on. It says parole hold. Did you know that? You didn't know that about your own one?
Probably the nose.
Yeah.
Pretty sure it's gonna be.
All right. The rest of the 3 pages are just 2 lawyers. Langston
Yeah, I'm working on the paperwork right now.
and David Grove. Is David even here? He wasn't here for the trial docket. That's the only 2 lawyers. We'll stand by short recess here.
Burkett. Good morning. Are you Christopher Burkett? And Mr. Burkett, this is your initial appearance. Give me just a second. Did you already open one? God, it takes forever. My computer's running slow. Give me a minute. And cause number 250358. You're charged with the 2nd-degree felony offense of burglary of a habitation, and that's from February 20th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? How old are you?
18. I just turned 18.
You did? Are you working? Are you in school?
No, ma'am, I'm not working, and I'm supposed to re-enroll into Paul Brown next school year.
Okay, if I test you this morning, you gonna have anything in your system?
No.
Let's double check that and then we'll see what we get worked out. Have a seat over there in the jury box. Michelle Johnston. Good morning, you're Michelle Johnston.
Yes, ma'am.
And Ms. Johnston, did you get someone hired?
I did. Y'all called him last time and he said he was gonna do everything, but I've had trouble with him before.
Who?
John West.
Okay,
At this point, I really don't even think that I need one because I have all the proof showing that I paid everything.
well, the thing is, I can't take that information and do anything with it. Did you pay him money?
Not yet, because he's.
So here's the thing. He's not hired until you actually sign a contract, pay him money. So he's not going to show up in court.
Mhm.
So if that's not going to work out and you're having trouble getting in touch with him, then did you talk to some other attorneys?
No, ma'am, because I figured that I could just do it myself, seeing as I have everything. And I don't have the money to pay when I always had a payment plan with him.
This is
Because when y'all called him, he said that he was going to do my representation last time I was here, the first time I was here.
right. But I can assure you, no one is going to represent you unless you pay them. That's just not how it works. Let's do this. Brittany's going to be here on regular docket, right? Stay here. I'm going to have Ms. Holmes, who was appointed to represent you while you were in custody, visit with you this morning, see if she can visit with the DA. And if it looks like something could get worked out, great. If not, then you're going to need to talk to some other attorneys and we'll talk about that.
Okay, because that's what it was supposed to do while I was in federal prison.
Okay, just have a seat in the courtroom. Don't leave until you talk to Ms. Holmes and we tell you what to do.
Okay.
Makisha Victoria. Good morning. Are you Makisha Victoria? Miss Victoria, did you get someone hired?
I'm just $25 short now, you see, so it's almost.
You're what? I'm sorry?
$25 short now,
Okay.
out, so I can, this now.
Okay, so, and who were you hiring?
Rice Kemper.
Okay, and so if I give you a couple of weeks, you'll be able to get that taken care of?
Yes, ma'am.
Okay, I'm gonna reset 2 weeks. You need to get that taken care of before the next court date,
Yes,
okay?
ma'am.
All right, step in front of the clerk. She'll give you your reset
Yes,
notice.
ma'am.
Monique Nguyen. Good morning.
Good morning.
Are you Monique Nguyen?
Yes, ma'am.
Miss Nguyen, did you get someone hired?
No, ma'am, actually, I've been calling around. There you go. One of them said that they can't help me because I have 2 cases, 2 charges, and then all the other ones, they only have 10,000.
Who'd you talk to?
James Makins, Will Hall is the one who said, we're the charge. Hall is the one who said he can help me. And Franklin, then I called, my attorney, Whitney Holmes,
Mm-hmm.
to see if she could represent me, but, she said that y'all gonna have to do that.
Okay, so I mean, you can, all right, are you working?
No, not yet. I'm gonna start by working, when I put, my kids in school, I have no babysitter.
All right, so thank you for talking to the lawyers like I asked you. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're gonna swear under oath that everything's true and correct. Step in front of the clerk and she'll give you that paperwork. Are you by yourself? Okay. Daryl Albritton? Daryl Albritton.
Daryl Albritton?
I think
No response, Your Honor.
this bond will be forfeited for non-appearance and reset at 100,000. Roderick Anders? Good morning, you're Roderick Anders. And Mr. Anders, did you get someone hired? Who'd you talk to?
Robert Thompson, James or Lincoln.
What's the last one?
Carlos Rojas.
Say it again?
Carlos Rojas.
Oh, okay. And so where are you on being able to get someone hired? Are you working? Where are you working? Okay, so I'm going to have you fill out some paperwork this morning. Thank you for visiting with attorneys. I'll see, put all your income, any bills you have, make sure you fill that paperwork out accurately and completely because you're going to swear your oath that it's all true and correct, and then I'll take a look at it. If you step in front of the clerk, she'll give you that paperwork. Mark Garcia. Okay, if you'll go ahead and call the name Mark Garcia, and then if he gets here, I'll, okay. And Summer had one too on the regular docket that just called. That McCorvey on page 8. Yeah.
Martin Ward.
No. It's reset. It shows reset.
Oh, is it?
My docket. It's on page 3.
I think he has a lawsuit because of county.
No response.
All right, his bond will be forfeited for non-appearance and reset at 100,000. He did call and say he was having car trouble, so if he gets here, I'll recall that.
Okay.
Gerald Jackson.
He called the bond and said he's having for a couple of trials.
Nobody's card. Gerald Jackson.
Gerald Jackson. Gerald Jackson.
Does Ryan know about his client's issue? At the top of that next page.
Hey, Ryan.
No response.
All right, his bond will be forfeited in all 3 cases and reset at 100,000 in each. He also apparently said they are having car trouble. If he gets here, we'll recall that. Shay Morgan.
That's my new client, Judge.
Okay.
She called this morning and said she's running late.
Okay.
We also know she's got a separate issue.
All right.
Make her aware of that, so.
You'll go ahead and call the name Shay Morgan, please. Thank you, Mr. Gertz. I'll go ahead and do the bond forfeiture, but then if she gets here, I'll recall it.
I've not met her in person, so I don't know what she looks like.
Okay.
For whatever that's worth. She's probably nothing.
We'll see.
Make
Nobody
sure
wants
she
to.
gets her. She's at least in communication with us. That's.
No response, Your Honor?
Her bond will be forfeited for non-appearance and reset at 100,000. If she gets here, we'll recall that. Goodness gracious, nobody wants to come see us today. Lance Charbino. I know. Good morning. Are you Lance Charbino?
Yes, ma'am.
And Mr. Charbino, were you able to get someone
I
hired?
had called Crenshaw Law Firm and Franklin and Associates. I was wondering if I can get a 2-month extension. I'd start 7/12 next Monday to be able to form me one.
Okay, so I always do 30-day resets. So what I'll do is, since you're giving me that information, you've talked to some attorneys, I'm going to do a 30-day reset. When you come back, let me know where you are on being able to get someone hired. And if you need that one more reset for it, then we'll try to get that taken care of, okay? All right, if you can step in front of the clerk. Shaniqua Washington. And if you'll make a note on there for me, just so maybe I'll remember. Well, just that he's starting 7/12 and should be able to hire someone within 2 resets. Have you decided which one or who you're going to hire yet?
I haven't decided exactly which one, but I've been talking with Crenshaw Law Firm a lot.
Okay.
And they sound pretty promising.
All right, just make sure you get that, at least have it narrowed down to who it's going to be next time.
Yes, ma'am.
Okay.
No response, Your Honor?
Good grief. Her bond will be forfeited for non-appearance and reset at 100,000. Christian Ainsworth. Thank you. Good morning. You're Christian Ainsworth. And Mr. Ainsworth, were you able to get someone hired?
I don't have it right now. I don't financial hardship.
Are you working?
Yes, ma'am.
Where are you working?
Raising kids.
Okay. Did you talk to some attorneys like I asked you to? Why?
Busy, if you remember last time, I told you my mom passed away, so I had to pay for partial of the funeral, so I was thinking, I don't need the money, so why?
But you don't know if you can afford or what you can afford until you talk to some of them. That's the whole point. And I understand that you had that loss and we worked with you last time, but you've got to get busy, at least do what I ask you to do. Otherwise, you're going to end up going to jail. And so I'm not sending you to jail because you can't afford somebody, but I'm going to send you to jail because you're not following my rules. And I said, this is a court order. And if you don't follow the court order, your bond can be raised for not following that court order, right? You have 30 days. You either get somebody hired or you talk to at least 3 lawyers in person and you bring me those names, or you will go to jail for not following that court order. Do you understand? Step in front of the clerk. It's like I'm hearing an echo of myself. Danelle Coleman.
I get it before the 30 days, can I come back?
If you get what, a lawyer? If you get a lawyer before the 30 days, just give that reset notice you get to them and they'll send us notice and it'll probably take care of that court date and you'll get reset out some for a different type of court date. Good morning, ma'am. You're Donnell Coleman. And Ms. Coleman, were you able to get someone hired? Who'd you hire? Okay.
That was appointed to me when I was.
And you went and hired him?
Yes, and he actually, I told you I just started working again.
Uh-huh.
So he was actually willing to walk down the normal cost they do for cases like this.
And did you already pay him or you need some time to do that?
I'm partially paid him. I still have a little more left.
Okay.
I can get paid every week.
Okay.
And he been bumped the price down for me to work with me.
And that's Mr. Rojas?
Yes.
Okay.
Over on the call.
Uh-huh. Okay. Mr. Rojas, that sound familiar?
Yes, we talked on Friday. No, not yet. You told
Yeah.
I think you
We
said.
talked about maybe with a lower amount. Yeah, but you haven't made that payment.
Not yet. I will be making it on Thursday.
On this Thursday. Okay, so I'm going to do a 30-day reset. Make that first payment or do whatever you need to do. Bring me a receipt if you haven't hired him all the way by the next court date. If you do get him hired before the next court date fully, then just stay in touch with him and he'll take care of that court date and tell you when to come. Otherwise, make sure you're here when we tell you, okay? All right, step in front of the clerk right here. She'll give you a reset notice. John Jones. Good morning. Are you John Jones? And Mr. Jones, this is your initial appearance and cause number 24-2154. You're charged with the state jail felony offense of theft of service, and that's from July 2nd of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Okay. How much do you receive a month?
$3,064.
Okay. Did you happen to bring any proof of that with you? Mm-hmm.
I can show you where the deposit is.
Okay, that's right. So what I'll do this morning, Mr. Jones, because of that, is give you a court-appointed lawyer. If you'll step in front of the clerk, she'll let you know who that's going to be. And if you have it now, that's fine. If not, okay, step in front of the clerk. Ronald Souls. Good morning, sir. You're Ronald Souls. Did you get a job?
Yeah, not yet, Your Honor. I've been working on it. And I did talk to my student. I had my girlfriend that talked to him. I think he was my favorite defender.
Uh-huh.
But he had told us to continue to do what you asked us to do, and I talked to another lawyer, and I was supposed to be untying him Tuesday.
Who's that? Just who is it?
Kim, right, Scott?
Rafe Kimler?
Yes, ma'am.
Okay, and you intend to hire him
Yes, ma'am, Tuesday.
this tomorrow, as in tomorrow?
Yes, ma'am.
All right, so I'm going to reset your case for 1 week to next week. If you get him hired this week, bring that reset notice to him. He'll tell you what to do. If he tells you you need to be here next week, then be here. If he gets a new court date, your bondsman and him will let you know. Otherwise, be here next Monday with proof that you've hired him, okay? All right, step in front of the clerk. She'll give you your reset notice. Patricia Benton.
And he can call his office and make an appointment to check them.
Good morning, ma'am. Are you Patricia Benton? And Ms. Benton, this is your initial appearance in cause number 25-0312. You're charged with the state jail felony offense of fraudulent use or possession of identifying information from November 29th of 2023. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? You're working? Okay, so since you've made bond in your case and you have a job, I expect you to at least try to hire someone. So what I'm going to do is reset your case for 30 days and order that you visit with at least 3 lawyers. They all charge different amounts, have different payment plans. You don't know if you can afford one until you start talking to them. If you get someone hired before the next court date, and also please stop chewing your gum. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they will tell you what you need to do. If you're not able to, again, I'm ordering you to talk to those 3 lawyers. Bring me those names back so I know you're trying, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Mr. Jackson, come on up, sir. I'll recall those bond forfeitures on Mr. Jackson. All right, Mr. Jackson, did you get someone hired? Talk to some lawyers?
Yeah, but I want the money to go get back a lot of job and my vehicle broke down. And I thought last time I was here, you told me that I was gonna be able to get the court appointed.
No, that's not what I told you, because I never say that. I told you to either try to get a job. I told you to talk to 3 attorneys because they charge different amounts. And that if you did all of that, then I would consider your options. But I never say I'm going to give you a court-appointed attorney. So that's not what I told you.
I already talked to the attorney before.
Okay.
And the last time I was gonna hire one, it was, he was from Orange and he didn't want to do Beaumont no more.
Okay. So did you try to call some Beaumont lawyers?
He referred me to somebody else and he was trying to charge me like a lot of money.
Who?
I'm not sure his name is something.
So you've been coming here for a long time. You know what I want. I want to know the names of who you've talked to.
His name was,
Why don't you just write it down? If I test you this morning, you can have something in your system. Have a seat in the jury box. Let's make sure. Mr. Parker, you have Jeremiah Davis.
I've sent Mr.
Jeremiah Davis. Hold on, let's see if he's.
You may not have got it. Yeah,
Morning, Mr. Smith. Good morning. Are you Jeremiah Davis? What does your shirt say? Just trying to figure out what it says. I can't read it. Make sure it's appropriate. Mr. Smith, announcement. Mr. Smith, Mr. Parker, announcement.
Your Honor, last time I asked the court for some time to provide a video to the district attorney's office. And my client and his parents came in and provided me the video, and I think it should.
If it was sent it to me last week, I was on vacation.
Okay.
And
ask for a reset, just give me a chance to review it.
Okay, we'll just do one more normal reset to give y'all time to take a look at all of that. Mr. Davis, stay in touch with Mr. Parker. He'll let you know when you need to be back. Okay?
I'm trying to talk, it's hard to see who's daughter. Okay.
You're free to go. David Lewis, Mr. Parker.
It's Preston's.
Preston's. No, you're welcome.
That's what's on his email.
It's contagious.
Took me forever. I could never email him forever.
I know, I still have a. All right, are you David Earl Lewis? And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Lewis, in cause number 240830, you're charged with the state jail felony offense of unauthorized use of a vehicle from January 26th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? Okay, is there anything specific that you don't understand? Okay, well, so let me ask you this. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So do you understand? That means that you can't change your mind if I follow this agreement and give you the probation. You can't change your mind later and say, oh, no, I didn't do it. Do you understand that?
Yes, ma'am.
And it looks like the agreement that you reached is for a 3-year deferred adjudicated probation with a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand that? And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone that. You're a U.S. citizen? You were born here in U.S.? Okay.
I think it's confused. I've explained to him that he's never been in trouble before, that you do everything you're supposed to do, you can possibly get off early, and I encourage him to do that.
So state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Lewis is not competent?
No, Your Honor.
Mr. Nichols, what's the state's position on waiving pre-sentence report?
I see no criminal history other in this case, Your Honor, so we have no problem with it.
All right, so Mr. Lewis, I'm going to waive the pre-sentence report, and I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm not going to find you guilty today. I'm going to follow that agreement that you made and defer all proceedings and place you on probation for 3 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity, because that deferred probation means you are not a convicted felon right now. And if you complete the probation satisfactorily and do everything you're supposed to, then at the end, the case is dismissed. You will never be a convicted felon. The other side of that, though, is if you violate any condition of probation, if you don't go to your appointments, you don't pay your fees, you test positive, you commit a new offense, whatever it is that you're supposed to do or not supposed to do, if you do that, then you could be brought back into court. You could be convicted, so you become a convicted felon, and you could be sent to prison for between 6 months and up to 2 years. Do you understand? All right. I'm handing you the trial court certification. That shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. The lady sitting right there at that desk, she's with probation. She's going to call you up when she's ready to go over your paperwork. Okay? Good luck to you, sir.
Thank you, Your Honor.
Thank y'all. Oh, it's in the air. This is bad. We're all saying the wrong names. Is what? Okay. Okay.
Judge Kobe is here. He's bouncing up and down from upstairs and down because he is witnesses for his trial, but he also knows he has several sentencing this morning.
Okay.
So he's here, it's just he's not always gonna be in the court. It's just,
Maybe when tell him when he gets in here to,
and then I did see Mr. Garrett's here. So.
yeah, get my attention so we can take care of his stuff. Mr. Rojas, you have Carnell Beard. Kelly just made up a name too. Yes. I said, oh my gosh. Good morning. This is Miss Malfino.
It is.
You do not look like Miss Malfino. Good morning, sir. You're Carnell Beard?
Yes, ma'am.
And Mr. Beard is charged in cause number 242414 with collision involving serious bodily injury. And what is the announcement?
Just last time we were here, we asked for a recess so that Mr. Beard could give me some information. I think there was a problem with email. I did finally get it this morning. He was trying to do it all last week. He finally got my correct email. I checked today. I do have it.
Okay.
If I can get one more reset, I'll look at all that stuff.
Okay, so you have it now.
I do have it.
All right, so we'll do one more reset. You can take a look at that, get anything to Ms. Malfino you need to, and then we'll get an announcement at the next court date. Stay in touch with Mr. Rojas. He'll let you know when you need to be back. You're free to go. You have Simone Dobbins. It's a sentencing, Mr. Rojas. Simone, oh, there you are. Good morning, Mr. Coleman. Good morning, ma'am. You're Simone Dobbins. And Ms. Dobbins was previously in court, entered a plea of guilty to the state jail felony offense of driving while intoxicated with a child passenger. I have received that pre-sentence report. Has everyone had an opportunity to review it?
We have, Your Honor.
Are there any additions or corrections?
No corrections, Judge, just one comment. I don't know if the court saw the probation department requesting 10 days in jail. I don't think that's a requirement for this type of offense.
It's not.
I would ask you not to.
I'm taking it off.
Okay, thank you. All right, anything, Mr. Coleman?
No, Your Honor, we just simply ask that the court follow the agreement of the parties.
All right, so Ms. Dobbins, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that for 4 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those is going to be that you enter and successfully complete the JCDI program. That is an outpatient treatment program, and that's what, after the assessment was done, that's what they say you need. Hopefully that's going to give you the tools to stay clean, get through the probation and not have any issues, okay? If you do everything you're supposed to while you're on this probation, then for all practical purposes, your case here in court is over, and you'll serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, then you can be brought back into court and you could be facing that 2-year sentence that you've already agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, you need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, ma'am. And then Zachary Turner.
Let's give you a sample. We would like to speak to you, and second, we tested that he don't think he's going to give a sample. So he's requesting to see you.
He has 2 minutes to give a sample, or I'm going to assume it's positive, and you can let them know that. All right, sir, you're Zachary Turner. And Mr. Turner, in cause number 24-2197, is charged with fraudulent use or possession of identifying information. Mr. Rojas, what is the announcement?
Judge, I'm asking for another announcement. Docket. Mr. Turner tells me he's been working out of tunnel on here, and I just haven't had a chance to sit down and look at all of this stuff. Objection, Judge.
All right, so I'm going to give you one more reset. Mr. Turner, it's important that you make time between now and that next court date to visit with Mr. Rojas, okay? So we need to get an announcement at the next court date. All right, you're free to go. Thank you. Mr. West, you have Ramadan Castillo. It's the sentencing in 3 cases. Morning. Ramadan Castillo. I think she's calling it.
Yeah, he's outside.
Oh my God.
Good morning. You're Ramadan Castillo. And Mr. Castillo, in cause number 22-40569, was previously here, entered a plea of guilty to the lesser included offense of indecency with a child. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, ma'am.
Any additions, corrections, explanations?
Reactions.
So here's the thing, Mr. Castillo, you said in here and were adamant in the pre-sentence report to probation that you did not do what you're charged you with. And if that's the fact, then you don't get to just plead guilty and take some deal and say, I didn't do it. If you didn't do it, then we go to trial and let a jury decide. And so I'm going to reject the plea agreement at this time. I'm going to set your case for trial. It will be on the next available trial docket, and we'll try all 3 cases. All right, stay in touch with Mr. West and he'll get prepared for trial.
Thank you.
Yeah.
I have another case on the designation docket from earlier. Ms. Johnson, I thought we had already seen earlier, and I know I've been talking to Tommy about the case since early on.
Who?
Michelle Johnston.
She's here.
Yeah, she's here. Yeah, absolutely.
Okay.
So I am her attorney. I thought we'd already sent everything in because, like I said, I've been negotiating with Tommy for months now. She was in federal custody for a while.
Okay.
So that kind of.
So are y'all ready to make an announcement today or?
No, Your Honor.
Okay, I'll reset it.
set for
Please make sure your staff gets that.
Yeah,
here.
I'll confirm and make sure that gets taken care of.
Ms. Johnston? Okay, Mr. West has said that you have hired him and he's been talking to the DA, so just stay in touch with him and then he'll let you know when you're next. She's got a reset already, so you need to get something filed to get rid of that court date.
I will. I'll talk to you later.
Robert Anders. Mr. Burkett? Oh, over here.
I'm sorry, Judge.
Nope, that's okay. Okay, when's the last time you smoked marijuana? On your birthday? Did you have fun doing that on your birthday?
I had fun on my birthday, not specifically because
When was your birthday? June 25th. So you're waiting to come to court and you think it's a good idea to smoke pot on your birthday, 3 days before court.
Yes, I understand those. Yeah. I don't have any intentions on smoking anymore. I don't want to smoke. I don't want to leave. I'm just trying to get this over with.
Okay, if you're trying to get this over with and do the right thing, those are great words that you're saying to me, but we're talking about, Mr. Kimley. What you're saying happened 3 days ago. When did you say your birthday was? Oh, okay, so 1 month ago, 30 days ago. Okay. So here's what we're gonna do. Because of that decision, you are going to be required as a condition of your bond to wear a drug patch. You have 24 hours to get a drug patch put on. Your bondsman lets you know where that can happen. It's a patch that you put on your arm. You have to go every 2 weeks. You have to pay to have it, and you have to get it tested every 2 weeks. It should probably be negative pretty quick if you really are telling me the truth that it's been over 30 days since you smoked. But it's going to tell me amounts. So it's not just a positive negative. It's going to actually, and if it's not going down, then I'm going to assume you're still using, your bond's going to be revoked and you're going to go to jail. That's it. Do you understand? So you have 24 hours again to get that on. Your bond's going to let you know. You have to give them proof of that so they know where you got it and where you're getting it tested. And then what I'm going to do, let's see. When are you supposed, you're going to go back to school, you said it. Have you looked into when that is? It's soon, right?
Yes, ma'am. It's so my grandma already. I should be already enrolled. My grandma's enrolled.
I want proof that you're enrolled also and that you're going to school. I'm going to give you a court-appointed lawyer as long as you're going to school. If you're not going to school, then you need to get a job. Do you understand? All right, step in front of the clerk. She's going to give you that information on your lawyer. Put the, for the bond condition, not just that, but also proof of school.
I have another question. Later on my actual birthday, like with the case, I have messages where someone sends the home.
Just talk to your attorney. You're going to get them today and they'll tell you what you need to do. Get them all that information. Probably printing all that out would be great.
You need to have a contact.
Do you have your grandma's number?
I don't know if I left my phone inside the car.
You left whose phone inside?
My phone. My phone is inside the car.
I thought you said you didn't have a phone.
No, I didn't say that. My phone is inside the car. I said I don't.
I just
Look, my phone's off.
You don't know your number?
It's off. It gets no number on it. I could go to the car and get the number off of my text now, but I don't have no.
It's like pay by the minute kind of thing, or what?
If I'm connected to Wi-Fi, I can receive and send calls.
Okay.
You're gonna have to be able to call this attorney and make an appointment to go see.
I can call as soon as I get inside the car.
Okay, well,
You just have to have Wi-Fi. Okay.
Okay.
All right.
Sign right here. You qualify.
Yeah, talk to.
Can you talk to him real quick? Written for attorney.
Just make sure y'all have each other's contact information, because his phone, y'all talk about that. Is Cody still down here? Mr. Burbank and Mr. Hoffpower, if you'll grab him, please. On Andrew Jackson. Morning. Good morning, sir. You're Andrew Jackson, and Mr. Jackson's cases are set for trial to begin with jury selection next Monday. And what is the announcement?
Your Honor, we've been speaking on it, but if we need to go to trial on it, we'll go on it, but we need Mr. Barker to work it out if possible, but.
That's today. If y'all want to work it out today.
I don't have time to, so let's try. I can't talk to my boss. I got to send it and stuff. But, to do this.
So, but y'all been talking last week?
Yes, ma'am.
Okay, so is there an agreement or not an agreement?
Well, if you remember, he pled.
I do remember. That's what I'm saying. If y'all haven't if y'all been working, but you're saying y'all are working on it.
We don't have an agreement set, so set for trial. That's all I can do.
All right, it's then going to be the number one case for next week to start with jury selection on Monday. I know you're in trial this week, but it just happens that way sometimes. So we will, if something changes today, y'all work something out within the next day or so, let me know and I will consider something. Obviously, it's not going to be the same thing that I've already rejected. But if something happens, I need to know quickly so that everybody else on the trial docket knows. But I do intend that probably to be the number one case next week. Okay, stay in touch with Mr. Burbank. We'll see you back next week.
Monique Quinn.
He's coming to the office this morning,
Okay,
so I'm hoping to.
all right, just let me, yeah. If you,
I'm shooting in the dark here.
okay, if something gets figured out, we can take care of it. Mr. Hoffmeyer will be here. If something works out, we can have y'all come in early one morning before we get started on the other case to work out something. Okay, yeah, just let me know. I'd be glad to get it taken care of if y'all can work it out, but it has to be this week.
Yes, ma'am. Thank you. Because I'm gonna be right here back on my stuff.
Do you, is there, well, let's get, what else do you have?
They've got Luke and Mr. Smith have my just dockets
Okay.
going for the pre-trial. I'm ready on all three of those.
Okay.
Jackson, Thomas, and I think it's Tom. Failure to register. Mr. Lewis. And Terrazzo with Mr. Gertz. Not Thomas.
Jose Colazo, Mr. Gertz. Well, we lost Mr. Gertz. You're ready on that
I'm ready
one?
on that, Judge. I'm ready on Jackson, and I'm ready on the failure to register.
Obviously, I'll take into consideration what all you've got, go in and number those accordingly on, those cases.
Thank you, sir. Anything else, Judge? I'm right here with you.
Thank you.
Gentlemen, got it.
Thank you, sir. Oh, wow. Mr. Jackson, come up, please. So, Mr. Jackson, you tested positive for THC, methamphetamines, amphetamines, and ecstasy. Obviously, that is a violation of your bond conditions to be using any type of illegal substances. In cause numbers 240706, 0707, and 1170, find that you violated the conditions of your bond. I'm going to raise your bond in each of those cases to $100,000 in each case. Condition of that bond, if you make it in each case, is that you wear a drug patch at all times. You can go back with the bailiff. That's why you didn't want to go potty. Mr. Gertz, on Jose Colazo, Mr. Hoffpower announced that he was ready. Jose Colazo, you'll call the name Jose Colazo.
Theoretically could be ready if we're number one. Ready if called. I'd rather not be 2 weeks in a row. But
Well, he's gonna be, so maybe both, because the top three are gonna be his anyway. It just may not be yours, it's probably gonna be Burbank's, but they're talking,
Everybody
so
loves the
you're getting
Burbanks.
close, but you're getting closer. His bond will be forfeited in each of his cases for non-appearance and reset at 100,000. If you get in touch with them, get them here this morning and I will consider that. And at this time, I'm going to number the cases for trial as well. Okay. Is there a Mr. Frank, Jonathan Frank here? Mr. Boudreaux? You have David Holland. Good morning, sir. Are you David Holland? And this is cause number 21-36992. Mr. Holland is charged with theft of service. And what is the announcement?
Judge, my client believes that he will be able, I'm not even explain it, but.
Hold on just a second. Did she go tell him? Okay, go ahead.
He'll be able to come up with $2,000 within about before the end of the week. And then he'll have $334 to pay. He'd like to have 2 weeks to do that. And then the DA's offer would be 30 days in jail for a misdemeanor. He only had the vehicle for about
Well, that's okay. So is that the understanding?
Yes, Judge, there was an alternative recommendation in this case of either state jail time or with the restitution paid up front, so county jail time. 3 days.
So I'm going to reset the case 45 days. No, 30 days, because you said 2 weeks.
I will say this, Judge, I'm sorry to interrupt the court, but that offer was made back on June the 4th. Judge, I mean, I would
So this is
expect
going,
to work
this
out.
will be the final reset. Either you get it taken care of, or there's some other alternative that will take place on that day. There will be no other resets, no matter what you say the amount is that you have to get. Either you get the money or you don't get the money. Okay? We'll see you back in 30 days.
Thank you, Judge.
Thank you. Mr. Flory? Mr. Flory? See, Mr. Jeffrey, you have a sentencing on Jerry LeBlanc, 2 cases. I'm doing fine. How about you?
I'm here.
All right, sir, are you Jerry LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered a plea of guilty in cause number 21-38605 to the state jail felony offense of theft, and in 22-40408 to the state jail felony offense of abandoning or endangering a child. The agreement in those cases was for a cap of 15 months in the state jail prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections?
Not from the state.
No, Your Honor.
All right, Mr. Jeffries, you may proceed.
Your Honor, I believe the most appropriate ending to this is probation. As the PSI report indicates, he would be a low risk on probation. I think just for context, a little bit of history on Mr. LeBlanc. He grew up in foster care. He did get into some trouble in his teenage years into the very early 20s. I believe the last time he got in any trouble, he was 21. He's in his 30s now. It's been 10 years since his last issue, and that was not a major issue that he had. And like I said, he was very youthful at the time. These situations, it's not a situation where he's going to go to prison forever and not come back. He's going to be back in society at some point. And what we ask is that we give him an opportunity to grow. Growth is important. Growth sometimes comes through very troublesome circumstances. In Mr. LeBlanc's case, the child involved in this particular situation has passed due to an illness. And that passing has has given him perspective that most of us want nothing to do with.
And it's allowed him to reevaluate his life and to see the mistakes that have been made and to grow from it in a way where he's actively contributing to his community. He's volunteering with kids. He's giving up his time and his finances to coach youth football, taking these kids all over the place, trying to teach them the way to do things to prevent them from following the same path that he's taken. Along with that, he does have a 5-year-old daughter that he's very active with, that he has custody of 50% of the time, and he's a strong financial supporter of her. And what we're asking the court to do is to take all that in consideration, along with the fact that PSI has him indicated as a low risk for probation, and just allow him to continue that growth.
Thank you, Mr. Jeffries. Mr. Smith?
Judge, the child that passed is the child that he left alone in the car in a parking lot at Academy while he and 2 friends went in and stole hundreds and hundreds of dollars worth of stuff, or attempted to steal. He basically says that was his buddies. He wasn't even doing it. They were all obviously working together. They covered the license plate with a rag so that they could make a speedy getaway. They didn't just go in and grab a few things. They had duffel bags full of clothing and items from Academy. He's been given probation opportunities before and was revoked. His criminal history speaks against him, and I believe I would ask for state jail time in this case.
Thank you, Mr. Smith. So I'm looking back, I'm not sure what has been the delay. These offense dates are from 2021.
Yes,
And it appears that
both,
August 27th, 2021.
and I believe November of 2022, Routine got 20 months state jail, and Brooks got probation 2 or 5. That was a cap plea.
Okay.
Your Honor, if I could add just a information. Mr. LeBlanc's position, he understands that he's accountable for this theft. His statements are just an indicator that he did not take any property away from Academy. He knows his cohorts did, and he understands that he's accountable for that.
Okay. I guess what I'm looking at is just the length of time. I mean, obviously there's criminal history, and I don't disagree with Mr. Smith that on paper, this does not look like you should be considered for probation in some ways because of you've been given an opportunity for probation. And just listen. Don't talk yourself out of what I'm about to do. But what I'm trying to say is that those revocations, the one revocation was back in 2014. Obviously, that's a long time ago. You were much younger. You have apparently not been in trouble since the date of these offenses, at least not here in that we or that probation discovered. And so you've been out on bond or doing whatever for some amount of time, doing the right thing. I appreciate that you're giving back. I appreciate the things you're doing. And it looks like you've grown up. You've gone through, I understand your child passing away. None of those things, however, makes it okay what you did. All right, so in cause number 21-38605, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft. I'm going to sentence you to a term of 2 years in the state jail prison, but I'm going to probate that for 5 years. You will be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 22-40408, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of endangering a child, state jail felony. Sentence you to a term of 2 years in the state jail prison, but I'm going to probate that, put you on probation for 5 years. You're also ordered to pay a $500 fine in that case, and you're ordered to follow all of the rules and conditions of probation. Part of those rules and conditions, you are to have no contact whatsoever with the co-defendants, Kendall Pushy and Marquise Brooks. You're also not allowed to go to academy. And I'm also ordering that you have to find, you're not allowed, I don't know if you're still using medical marijuana. You cannot use that. Because the facts in this case looks like you were doing more than just using medical marijuana. Hang on. When there's scales and stuff involved, that's not somebody that's going to get medical marijuana. And that's what was inside the baby's backpack. All right. Okay. So if you test positive for marijuana, it is a violation of your probation. You will be right back in here facing the 2-year sentence that I gave you today. No negotiation. I just gave you the max, 2 years. Okay. If you follow all of the rules and conditions of probation that you're supposed to, then for all practical purposes, your case here in court is over. You'll be able to serve those 2-year sentences while you're out on probation. But again, the other side of that is if you violate any condition of probation, you'll be brought back here and you'll be facing those 2-year sentences that I just gave you. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Jeffries. You need to have a seat here in the courtroom. Probation is going to call you up when she's ready to go over your paperwork. Good luck to you, sir. Thanks, Mr. Smith. Thank you, sir. Mr. Kimler, you've got Aaron Ashcraft. This is pretrial. Good morning. You're Aaron Ashcraft. And in cause number 24, in cause number 24-2192, Ms. Ashcraft, you're charged with harassment of a public servant. Your case is set for trial to begin with jury selection next Monday. And what is the announcement?
Got a vacation letter in starting on August.
Okay.
But I'm ready on the case. After,
Okay.
I think I'm especially set next to on August 25th.
Okay. And you've confirmed that?
Yes, ma'am. Yes, ma'am.
Okay.
I wouldn't be.
No. Okay. Yeah. Okay. And there's nothing that's going to get worked out on this case?
I never would rule that out. It's possible.
Well, that needs to happen today. So if it's going to get taken.
You want to do 2 years for first probation?
All right. So I'm going to reset it. There will not be that offer taken after today. So that's fine. That's what juries are for. Let a jury decide. But I want to make sure when we get here and ready for trial, there's no, oh, I want to take the 2-year deferred that day. It would be a plea to something different, or you're going to trial and let a jury decide. Do you understand?
Open to the court.
Yeah, something, yes. Okay, I'll reset it on the next available trial docket. Stay in touch with Mr. Kimler and your bondsman. They'll let you know when you need to be back for trial. Okay? You've also got Jason Harris,
He's in
Mr.
the
Kimler.
back, Your Honor. Mr. Coleman.
He has,
AFRS.
yeah, let's get him, please.
Mr. Coleman had.
Hold on. Let's get him out here, please.
Take it easy. You're right here.
Good morning, sir. You're Jason Harris.
Yes, ma'am.
And Mr. Harrison, cause number 242254 is set for trial to begin jury selection next Monday. I know you've got a vacation letter in.
Yes, Your Honor.
Sir.
Mr. Coleman had offered 180 days state jail for today.
Mhm.
I didn't do it.
Hold on, that's fine. Just
But
hang
Mr.
on.
Harris has advised that he's refusing that, so it's still good trial.
Okay, so Mr. Harris will get your case moved to the next available trial docket. Mr. Kimler has a vacation letter in for next week.
What about this situation?
That's on your-
I recorded everything I'm supposed to do, and I'm in custody.
That's between you and your bondsman. They filed an AFRS to get off of your bond. It's an affidavit to release surety. And so if something happened between you, that's between you and your bondsman. That's not my warrant. I mean, it's my warrant, but because they filed that. So that's, we'll reset your case to the next available trial docket. I do want to make sure you understand that after today, I will not accept that plea agreement. It's off the table. Okay. Okay, then we'll get your case set as quickly as possible.
I'm not sure if the court doubled the bond, but we would ask the bond to set the original amount.
No, I'm not prepared for bond here today.
No, I'm not going to set it at the original amount if there's an issue with the bond. Just make a note for me to take a look at that AFRS later and see why. All right, go back with the bailiff. You have Renasha Payan, so sentencing.
It's Renation.
Renasha.
I want you to recall.
All right, are you Renasha Payan? And Ms. Payan was previously in court, entered a plea of guilty to the third-degree felony. Shh, y'all. Good grief.
Listen.
Take a breath. All right. Ms. Payan was previously in court, entered a plea of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's in cause number 242107. There was no agreement. I have received the pre-sentence report and reviewed it. Is there, has everyone had an opportunity to do that?
State has you.
And it looks like there were also some letters that I reviewed that were attached to that. And has everyone had an opportunity to review those?
Yeah.
Yes, Judge.
In addition, Mr. Coleman has also filed a state sentencing memorandum, and I've reviewed that as well. Mr. Kimler, have you had an opportunity to review that? All right, this was open to the court. Mr. Kimler, you may proceed.
Yeah, as far as the pre-sentence report itself, there's one thing that I wanted to address at the outset. It's the allegation she has some type of gang affiliation. I noted that was first mentioned in the citizen, that there was some type of report, a post investigation.
I can't hear you.
I'm sorry, there was some, and I'm looking at the gang affiliation portion of it. That there was some type of post-investigation report dated May 4th of 2010 that the pre-sentence investigating officer reviewed. It said that report, which is not included in the PSI, revealed records that linked her to the 5 Deuce Hoover Crips, which I have no idea what that's about. I've known Ms. Payan, our representative, going on probably 15 years now, and I've never known her to have any type of gang affiliation. I don't know what that report is, and evidently it contains hearsay within hearsay. But then that in itself is not so much of a concern, but the reporting officer then goes on to include in the recommendation portions an assertion that her history includes gang affiliation, which I would take issue with. First of all, I don't even know what they're referencing.
That's fine.
I've never known her to have any type of gang affiliation.
Okay.
What that leaves us with then is an unfortunate incident where Ms. Payan possibly could have been charged with something more serious. It's going to arrive. Mr. Coleman will address that as far as the shooting altercation where a gun was displayed and discharged by her passenger. And while Ms. Payan is not charged with anything in relation to the discharge of the firearm or the altercation, she was in the midst of that situation. In that context, evaded the police, evaded the law enforcement. I think the court could reasonably infer from the factual, uncontested facts in the PSI that she was in a highly emotive state during this incident where the vehicle in which she was riding or which she was driving had been under assault by people around the shooting, which is probably understandable. And again, she had injected herself into that situation, but she was in an agitated state of mind when she was driving away under the, I guess, the flight instincts with imminent fear that she was operating in that type of mental state. The police officer observes that she did go through a couple of stop signs while he was behind her, but then that she came to a stop. So this wasn't a situation where there was some sort of extended high-speed chase where spike strips were deployed or the vehicle crashed or something like that. I suppose, and again, not to speak on Ms. Kayan's behalf, but once she was able to put some physical distance between her and the situation, and she calmed down somewhat, that the rational portion of her brain reasserted itself, and she knew that she was being pursued by law enforcement, so she came to a stop with that incident. She regrets this incident. She's been looking at her criminal history. I know she does have criminal history, including prior probation revocations for felonies. But even at the misdemeanor level, I think it goes back 12 and a half years before she, that she's had problems. So there's been at least a 10-year period here where she's maintained a law-abiding lifestyle. And but for this poor decision to inject herself into this situation with one of her friends, she wouldn't be standing before the court. She has a GED. She has employment history. I think she regrets what happened. And even though I know Mr. Coleman probably is going to reiterate to the court that she's had prior probation failures, that's where a time when she was younger and less mature. I think that with this opportunity for the court to get her to complete this probation, she would not let the court down.
Thank you, Mr. Kimler.
And then she would address the court. If you want to tell the judge anything.
Everything that he's been is so true from my past and everything. And if you guys give me a chance, I will let you guys down.
Speak up.
I said, if you guys give me a chance, if you give me a chance, this way, so I won't let you down. I won't let myself down.
Thank you. Mr. Coleman?
Your Honor, the court's indicated that you read the sentencing memorandum. I don't have anything to add other than just briefly for the reasons stated in that sentencing memorandum, including the defendant's criminal history, the 3 previous probation revocations, and the underlying circumstances. We don't think that probation is appropriate, and we ask for prison sentence. The last time she went to jail was for 2 years state jail. We asked for a PCP in excess of more. Thank you, Judge.
So she went for 10 months.
I also saw
Is there
2
something else?
years state jail sentence on 2011 possession of controlled substance. That's what my notes show, like on the PSI.
Oh, I see that one then it was, well, it looks like she was shocked out. And then that didn't work. Yeah, okay. I see what you're saying. Why don't you work?
Right now, I'm not working because I had health issues, but I got a job on July the 2nd, and I left the court for remodeling homes. But right now, I wasn't able to work this. I had doctor's appointments and stuff like that to get my stomach checked out, to see a specialist on it.
Who's your doctor?
My Gulf Coast, Mr. Jordan. Dr. Jordan. That's important.
What about the person that was in the car that claimed, was it Banks that claimed the purse that had the gun in it?
Yes, that's my understanding, Judge. Was it the passenger?
And was she charged or he?
I don't know.
Case number 24CR42236, the state of Ohio versus Scott Combs. Mr. Combs is before the court with his counsel, Mr. Gibbs, Ms. Nicholson on behalf of the state of Ohio. Mr. Combs, your attorney had filed a motion for intervention in lieu of conviction. So in a moment, you'll be asked to change your plea to guilty to the counts of the indictment. The court accepts your plea but does not make a finding of guilt. Instead, I will hold your plea in abeyance or set it aside and require you to complete a plan of intervention. If you successfully complete that plan of intervention, then the prosecution of this case ends with no finding of guilt, and I'll dismiss the charges against you, okay? However, the other side of that coin is that if you fail to complete the plan of intervention, if you continue to use illegal drugs or you break the law, I will be able to make a finding of guilty that's based on your plea today, and then I'm going to sentence you. You understand that part of it?
Yes, sir.
How old are you?
48.
How far did you go in school?
Some college.
So you can read and write?
Oh, yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you if you fail to complete ILC?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation that you received from Mr. Gibbs in this case?
Very much.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take any medication that interferes with your ability to understand what's going on today?
No.
I have in front of me a document. This is called a change of plea. On the second page on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of aggravated possession of drugs as a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. The second count is one of possession of drug paraphernalia, a misdemeanor of the 4th degree. That carries a maximum penalty of 30 days in the Warren County Jail and a $250 fine. And the third count is one of obstructing official business, a misdemeanor of the 2nd degree, and that carries a maximum penalty of 90 days in the Warren County Jail and a $750 fine. Do you understand the maximum penalties?
Yes, sir.
In addition to those penalties, you are also subject to a discretionary period of post-release control, which means that if you are sent to prison on the felony upon your release, the adult parole authority may choose to supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on post-release control, whichever is longer, and that time would be run consecutive to any other prison time you're sentenced to. Do you understand that?
Yes, sir.
But as I've said, it's not mandatory that you're sent to prison at all. The court does have the discretion to place you into community control if you fail to complete ILC, some call probation. There will also be rules you have to follow while on community control. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury must find you not guilty and their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
I do, sir.
You understand that when you enter plea of guilty, you'll be waiving all these rights. We will not have a trial.
I do, sir.
This is how you want to proceed?
Yes, sir.
All right, Ms. Nicholson.
Your Honor, if this case was proceeded to trial, the state would have proven beyond a reasonable doubt that on or about December 2nd, 2024, in the city of Middletown, Warren County, Ohio, law enforcement made contact with the defendant and asked him to stop. He was seen leaving an old business. He took off on foot, and there was a short foot pursuit before he was apprehended. He had an outstanding warrant, was placed under arrest for obstructing a search incident to arrest, located approximately 1 gram of methamphetamine in his pocket, as well as a glass pipe with residue and burn marks.
All right, Mr. Gibbs, anything on those facts?
Nothing further, Your Honor.
All right, Mr. Combs, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge what she said is true?
I do, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed.
Yes, sir.
What is your plea?
Guilty, sir.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court accepts your plea of guilty. I am going to grant your motion for intervention in lieu of conviction and order these proceedings stayed pending the completion of the terms of that supervision. So you will be in ILC for up to 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from use of any drugs, alcohol, or marijuana. There's no THC in any form. You have been accepted into mindful healing. You are ordered to complete the residential treatment program successfully with any recommended aftercare. You will be placed on electronically monitored house arrest while you are at that facility. There's a $205 reimbursement to the Middletown Police Department. You have 68 days jail time credit as of today. Does that sound about right?
Yes, sir.
Ms. Nicholson, is there anything else?
No, Your Honor.
Mr. Gibbs?
Nothing further.
All right, probation will be transporting you to mindful healing. Okay, sir?
They will be taken?
Yes, sir. Good luck. Oh, mindful healing's here.
I'm here. Hi, Your Honor. I'm Kelsey Bird from the Housing Director at Mindful Healing Center. It was brought to my attention today that I would be transporting him.
Okay.
I will wait.
Officer Sukavecki, I guess you'll let community corrections know to slap a monitor on him. I'm not sure how long. If you'll go with Officer Sukavecki down to court services, and then we'll get him hooked up to monitor, and you can transport him.
Thank you, Your Honor.
All right. Thank you.
I appreciate it, Your Honor.
Yes, sir. Good luck.
Thanks, sir. Appreciate it.
Is that typical?
What's your relationship to that person that was in the car?
What was just the kid?
Female.
The female. But she did get charged.
She did.
Yes, ma'am. She's on probation.
She is.
Yes, ma'am.
Okay, so Ms. Pyan, I mean, Mr. Coleman makes good point. You have criminal history. It's kind of similar to one we just talked about, but it's all old and you've been doing so well for so long, but this was a scary situation that could have been ridiculous. I mean, people could be in here. It's the same thing. I feel like I'm a broken record. I mean, people don't just argue and fight anymore. Somebody always starts shooting every single time. So I wouldn't put myself in that position. All right, what I'm going to do, Ms. Pyan, is find that you entered your plea of guilty freely and voluntarily. Find that you are mentally competent, understood the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time I am going to find you guilty of evading arrest or detention with the use of a vehicle. I'm going to sentence you to 10 years in prison, but I'm going to probate that. You're going to be on probation for 10 years. I'm ordering you to pay a $1,000 fine and to follow all of the rules and conditions of probation. This opportunity is giving you the opportunity to serve the time that I just gave you while you're out on probation. So if you do everything you're supposed to while you're on probation, you'll be able to, for all practical purposes, your case in court's over. You'll serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, I just gave you a 10-year sentence, which is probably more than Mr. Coleman was asking for today, and probably more than I would have given you if I'd sent you to prison today. So you're getting an opportunity, but the downside of it is if you violate it, things can be a whole lot worse than they could have been today. Does that make sense? So don't make me regret this. If you do everything you're supposed to on this probation, you can even get off early, but that takes you doing things very differently than you have done in the past. So you know what probation's about, you know what to do to get off of it, you know what to do to end up getting in trouble. I'm going to hand you the trial court certification. This was not an agreement. You have some rights to appeal. You can talk to Mr. Kimler about that. Also, I'm handing you the trial court written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. You need to have a seat here in the courtroom. Probation is going to call you up when she's ready to go over your paperwork. Good luck to you, ma'am. Mr. Kimler, you have Johnny Polanco. Johnny Polanco?
Yes, ma'am.
Good morning, sir. You're Johnny Polanco?
Yes, ma'am.
And Mr. Polanco's case is set for trial to begin with jury selection on Monday. Is there anything that can be worked out today?
I think it's a penitentiary time offer. He
Okay.
conditionally, I said, the case Mr. Smith is represented that will be picked up by the.
So,
federal
Mr.
government.
Polanco, Mr. Kimler has a vacation letter in for next week, and so we are going to reset your case to the next available trial docket. I do want to make sure that you understand that whatever offers on the table today will not be accepted after today. So if you change your mind and you want to enter a plea today, we can get that taken care of. Otherwise, it'll get set for trial. If you later change your mind, you could plea open to the court or to something different than what's on the table today. Do you understand? Answer out loud.
Yes, sir. Yes, ma'am.
And so do you want to stay on the trial docket?
Yes, ma'am.
Okay. We will move it to the next available trial docket. Stay in touch with Mr. Kimler and your bondsman. They'll let you know when you need to be back.
Thank you, Your Honor.
Who's that?
You took the drug test and I took his bond.
Oh, did he?
Yeah.
What kind of?
I don't know if EMS is here.
Oh, are they going to come through?
I think they're went to back.
They're already back there?
Yeah.
Do we need a break or are we good? Okay, just tell me if we need a break. I know. I was just looking to see. You want to ask him? Call him up and ask him. Mr. Albritton, come up, sir.
Okay.
Hang on a second. All right, sir, you're Daryl Albritton. Let me find you. It's very important, Mr. Albritton, that you're here on time, okay? Okay. Where do you work? Okay. So I'm going to recall the bond forfeiture. Did you get someone hired? Speak up and loudly and clearly so I can understand you. Did you talk to some lawyers?
Yeah, well, they told me I got appointed lawyer, and he told me.
What did I tell you last time you were here?
He told me to find my own lawyer.
Right, and what did I tell you about that specifically? How many did I tell you to talk to?
5, 4,
3.
yeah, 3.
And to bring me their names. And if you didn't do that, what can happen? Do you not remember? Do you not remember? What were your hours? What time did you work?
I work 5 to 4 o'clock.
5 a.m.
Yes,
to
ma'am.
4 o'clock p.m.? For what
Okay.
company specifically? What company do you work for specifically? Apache?
Yes, ma'am.
Do they drug test you?
I don't smoke nothing. Yeah.
Well, you're making me wonder if you're not using drugs, why you're not thinking clearly and doing what I asked you to do.
I'm gonna do it. This time, I promise.
This time you're going to do it. How many times have you been here?
Oh, 3, 4, around there.
How much do you make an hour?
26.
You have 2 weeks. Hire a lawyer within 2 weeks or talk to 3 lawyers. Listen carefully. Hire someone within 2 weeks, or if you cannot, talk to at least 3 lawyers in person, on the phone, something. Talk to them. Bring me those names. Tell me what they told you. You need to write it all down. I want to know what they're charging. I want to know that you actually talked to them. Don't just look it up and say, I talked to 3 lawyers. I want to know what you found out. If you do not do that, you will go to jail on the next court date. There will be no excuses. 2 weeks. Do you understand? Is there any question about what you're supposed to do? All right, step in front of the clerk. She'll give you a reset notice.
And that's that information.
Oh, I called that Flory. Let's see, Mr. Is it Comerford? You're here for Mr. Flory? Sorry, I said Mr. Flory's name earlier. You might not have heard me. On Simon Gobert?
Yes, he's present.
It's a fairly new case.
Good morning, sir. You're Simon Gobert? It's actually 500 days old.
Oh, I just got.
That's okay. New to you.
Yes.
Let me get it pulled up real quick so I can take a look at it. Okay, yeah, it looks like you guys subbed in June. And this is 240512. And goodness, everything's moving slow now. And Mr. Gobert's charged with attempt to commit sexual performance by a child from August 2nd of 2023. And what is your announcement? Obviously, is that you need some time.
Review discovery.
Have y'all already requested and received most of that through the portal?
Yes, I've gotten the paper discovery. I just need to get the media footage.
Okay. All right. Is there any notations for Mr. Hoffhoward? Any issues?
No, Your Honor.
All right. So we'll just do a normal reset. That's about 30 days. Give you time to get that media. Mr. Gobert, make sure you stay in touch with your lawyer so that once they get that, you can go visit with them and we'll get an announcement at the next court date. All right. Thank you. Y'all are free to go. Mr. Rennick, you've got Alexandria Bledsoe.
Yes, Your Honor.
Good morning. Good morning. Are you Alexandria Bledsoe? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Have you got that discovery, sir?
I do have it right here, Your Honor.
Ms. Bledsoe, in cause number 25-0004, you're charged with the state jail felony offense of abandoning or endangering a child with intent to return from November 4th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Unfortunately, yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rennick? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Ms. Bledsoe is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that I can get a pre-sentence report done. It'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay, we'll see you back at sentencing. And then you've got, okay. All right, we're going to take, ladies and gentlemen, we're going to take about a 10-minute break. If you're on the docket, don't go far. You're going to get called back in, or you can just wait in here, but we need to take just a short break. Court will be in recess.
Mercy Bruno? Yes. Okay. Hi. You are charged, you probably know this, with the second-degree felony of burglary of a habitation, which carries with it, if convicted, up to 20 years in prison. David Grove is your attorney, who's been appointed to represent you. Have you had a chance to speak with him at all?
Oh, well, yesterday I did.
Yesterday? Okay. Oh,
No, can you please, restate what you're saying? We can get to know the number you say.
uh-huh. He's not going to be here today. He's unable to be here today. So I'm going to reset this for a week.
Oh,
Okay?
okay, that's,
All right. Thank you. Jador Ernest. Jador Ernest.
That plea is ready. Got one of the sentencing. Now sentencing to. I haven't said, but I've got that.
Jador Ernest, please come on up. 24 CR 1309. You were charged here in this indictment with the third-degree felony of engaging in organized criminal activity, which carries with it up to 10 years in prison if you're convicted. The indictment goes on to allege you have some prior convictions, burglary in violation of a protective order. So that was a conviction out of Harris County in 2022. So if you were found guilty of this engaging in organized criminal activity indictment, and then one or both of those prior convictions were proven true, then your punishment range becomes a second-degree felony. So you were looking at up to 20 years in prison. Do you understand?
Yes, sir.
Has anybody talked to you on this? You haven't had an attorney speak to you yet?
He came yesterday.
Okay. Did y'all talk?
Yes, sir.
Okay. All right. He's not going to be able to be here today. Well, I'm going to reset it a week. Thinking about I don't want to talk about the case, but was there an offer that was made?
Yes, sir.
And did your attorney talk to you about that?
No, sir, so I'm gonna try to get him probation.
What's the offer?
It's not probation.
Okay. All right, so we're gonna have to wait till, we have to reset 1 week. And it looks like they're not offering it, and that wouldn't be surprising with a criminal history like that. So it may end up having to get tried if y'all can't agree otherwise, but we'll reset it 1 week and bring you back. Okay, so all right, thank you. Carl Ledette. Carl Ledette, please. 25 CR 579. Okay, 25 CR 579 is called Carl Ledette. Is that you, sir?
Yes, sir.
And Mr. Grove is your attorney who is unable to be here today. Did you have a chance to talk to him yesterday?
Yeah.
He was in the jail yesterday talking to some people.
Yeah.
He's unable to be here today. As you know, you're charged with this first degree felony, which carries with it, if convicted, up to life in prison.
Yeah.
We're going to have to reset this for a week. And I don't know where, since he's not here, I don't know what he's going to announce on your behalf. But there's not much I can do without the lawyers.
I understand. This is what I'm saying. Oh, yeah, he had came see me. Just want to speak brief on it.
Sure.
Yeah, he had came see me, and I was well, all thanks to it when he was telling me that there's no evidence on it. It was like it's just none at all.
Okay.
And
well, I think the state disagrees, but or they wouldn't if they felt like there was no evidence, it wouldn't be proper for them to continue to move forward, and that would be in bad faith. Okay. And sometimes they dismiss cases.
Yeah, that's what
but this is
child support. We call it CPS in Louisiana, but y'all call it Ferguson. The name of that CPS place.
Did Mr. Grove review with you the probable cause affidavit? That's the probable cause affidavit that is signed let's say by a police officer here who investigated the case.
Yeah,
did he review that with you?
The detective?
Yes.
Yeah, the detective had he didn't put it in there that I told him that.
Okay. He needs to stop talking, Judge.
Yeah, it's best. Yeah.
Okay.
Yeah, don't want to say anything without your attorney here.
Right.
Because that's a plan y'all have. But he's not going to be able to be here today. We're going to have to reset it a week.
Okay, a week. Is there any other kind of way that I can get another appointment on?
When you're appointed somebody, and this was indicted 2 months ago. Was it yesterday? Was it the first time you talked to him?
Yes, sir.
Okay. Well, I'm going to reset it 1 week, and we'll see what happens in a week. Okay.
Yes, sir.
All right. Thanks. Yes, sir. Leonardo Mendoza, please. Miss Tom, that's yours.
Hey, Judge. Let me ask you for. Hey, Judge. On my left. On my innocence. Yeah.
In the other cases, yes, gotcha. Okay.
We just need to, dot the i's and cross the t's on that for that to work right.
Yeah.
Okay. Okay.
Second degree felony.
Next was Mendoza. Yes, sir. Thank you. Leonardo. Mr. Mendoza, that's you?
Yes, sir.
Come on up. It looks like there's a motion to revoke probation. You have an unauthorized use of a motor vehicle case that you were on probation for.
Yes, sir.
And then now there's a new indictment in April of this year that states that on or about February 18th of this year, you committed theft of a state jail felony of theft of a firearm. And I'm looking at the motion to revoke unadjudicated probation. And number one, it says that on or about February 18th, 2025, the defendant committed the offense of deadly conduct and theft of a firearm in violation of his probation order. Does he have was there a third case? I only have two, the motion to revoke probation and the theft of a firearm. What about the deadly conduct? Was that indicted?
Received an email from the district attorney about that.
Uh-huh.
Let me see.
Sarah
Yes, Your Honor.
is the prosecutor on Mendoza.
Yes, Your Honor.
I see an indictment for the theft of a firearm.
It's a misdemeanor.
Oh, it ended up being a misdemeanor?
Yes, so the deadly conduct is a misdemeanor.
Okay.
The deadly conduct is, he does have the new theft of a firearm.
Okay.
At the interior.
All right. All right. Good. Okay. Did they file a new misdemeanor case on him too?
He did, Your Honor.
All right. So you got two more new charges.
Yes, sir.
The state jail felony of theft of a firearm, and then that misdemeanor of deadly conduct. Also here on this unauthorized use of a motor vehicle, it's a state jail felony. So if your probation were revoked, you'd be looking at up to 2 years in state jail.
Yes,
So
sir.
this is all serious. Have you had a chance to talk to your attorney, Mr. Grove?
No, sir.
Okay. All right. We're going to try to get him over to see you as soon as possible, because you can't really do much without getting advice from your lawyer first.
Sure.
Okay. We're going to have to reset this case for a week. Okay. So I can make sure that he gets to you and talks to you about what options you have. All right. Okay. All right. Thank you. Sir.
I didn't know.
Sergeant Lee, conducting the traffic stop, approached the defendant's vehicle. Defendant refused to comply with orders. Officers observed a handgun located between the seats that was ready at hand. They observed defendant making what they believed to be movements towards that handgun with his right hand. Trooper Valentine attempted to extract the defendant from the vehicle and attempted to actually assist Sergeant Lee in extracting him from the vehicle, made his way across the seat and ended up taking a fall, which resulted in a broken kneecap to Trooper Valentine. Defendant was eventually secured. Handgun was recovered, found to be an operable 9mm Springfield Hellcat. In addition, a bag of cocaine in an amount of 28.19 grams was recovered along with the digital scale with white residue.
Mr. Kirby, anything on those facts?
Nothing on those facts, Judge.
Mr. Meeker, did you hear the statement that she read?
Yes.
Do you admit and acknowledge what she said is true?
Yes.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed.
Yes.
And what is your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Mr. Kirby, you wish to be heard on the issue of sentencing.
Yes, Your Honor. As the court's aware, my client was in a pretty bad car accident. He does have some follow-up appointments that need to be attended, one of which is in August with a neuro doctor at UC. We would ask for sentencing to be set out for after that date.
Ms. Tranter?
Your Honor, I don't have an objection to that with, as I stated, the caveat that if Mr. Meeker fails to appear for that future sentencing date or picks up any new charges in the meantime, the state would not be submitting that agreed recommended sentence of 4 years to the court.
Okay, Mr. Meeker, it is my intention, and I always do follow the recommendations of the prosecutor and your attorney with regard to sentencing. I've never deviated from that. That being said, you've heard from the prosecutor. I am going to grant the request and let this be set for sentencing out at Mr. Kirby's leisure in the next few weeks. I expect you to continue to comply with the terms and conditions of your bond, which means that you'll remain on monitor. You're not permitted to use any illegal drugs, alcohol, or marijuana. You're not to break the law. Any deviation from this or failure to appear at your sentencing hearing will result in the state withdrawing the agreed recommended sentence to this court, and then I am free at that point in time to sentence you along the lines that I've outlined here today. Do you understand all of that?
Yes, Your Honor.
So you're looking at 18 and a half years in prison. I would guess that you'd want to comply because you pretty much cut that down by 75%. So just a word of caution to you. All right, you'll talk to Jennifer and get it set for sentencing.
Sounds good. Thanks, Judge.
All right, thank you all.
Dawn and Duster on my.
I'm sorry, say that again.
I didn't have Dawn and Duster as my attorney.
Don Dusler?
Yes, sir.
No, David Grove has been appointed to represent you.
Yes, sir.
Okay. Small? Yeah, Clarence Small. What are you doing? Oh,
Waiting for Gary to right here to accept right now. Oh, well,
Jones?
yeah, Barbara Jones.
Mississippi.
Come on up, sir. You're Clarence Small. Mr. Grove, David Grove is your attorney?
Yes, sir.
Have you had a chance to talk to him?
No, sir. Not since we came in here on the 7th of July. He said he needed 4 weeks to get my timeline. He didn't know my timeline.
Okay, well, yeah, obviously, he's not going to be here today. We're going to have to reset this case for a week.
Okay, yes, sir.
We need to work with him on what direction this is going to head in, so that you,
Yes, sir.
so I know and you know. Okay.
Yes, sir.
All right. Yeah. I'm going to get him to talk to you as soon as possible, sir. So
Okay,
we're going
yes,
to
sir.
reset it 1 week.
Okay, yes, sir.
All right.
Thank you.
Thank you. Monica Vincent.
And Mr. Kimber said he needs Glover out.
Sure, if he's the author of the question.
You know, I've got his co-defendant,
available to testify against him too.
Monica Vincent, that's you. In 24 CR 2342, as you know, you're charged with this third degree felony of evading arrest. And then it looks like there's some prior convictions in 23 on assaults on a public servant. So this third degree felony, if all of this is found true in the indictment, the prior convictions and in this event, then the third degree becomes a second degree. It gets enhanced one level. So you're looking at up to 20 years in prison. Has David Grove had a chance to speak with you? He's your attorney who was appointed to represent you.
Yes, sir, not recently, but you recall about 2 weeks ago.
Oh boy. Yeah. There's only 5,000 cases I have.
I heard David dies.
Did you?
And you said that he hasn't sent you any
He
information.
hasn't. There's nothing in this yet.
And what Mr. Dice told me was, because I think he was from Orange, but he's out of Kima now, and he said that he was going to do the legwork, but Grove was going to represent him in court. I don't know. It sounded odd to me too. So I don't know what they've talked about. I haven't spoke to any of them since I hired Mr. Grove.
And Mr. Grove's not here today. So yeah, he's been appointed to represent you.
Yes, sir.
And we're going to have to reset this a week.
Understand. Yes, sir.
All right. I hate to postpone things, but
Yes, sir. Thank you, Your Honor.
that's just, you're saying you've hired Mr. Dice, but there's nothing in here that the proper way that someone comes into a case is by a written documentation that shows that they are going to be representing you until or unless that happens. The attorney, if you were appointed attorney, that attorney continues unless or until the court replaces that attorney. But you can always hire anybody anytime. Meanwhile, how long have you been in jail?
Since November.
Yeah. It will be a year in a couple of months, won't it?
And
How's that going? You know, I know.
it's hard.
Yeah. Okay. We're going to reset it a week and see about getting you and the lawyers together. Okay. Thank you. Thank you. Okay, who was that?
Glover Jones.
Okay, I need Glover Jones. Glover Jones. Please. Do I have one case?
I think
Robert. Oh, boy. What do we have? Habitual felon?
Probably. I noticed there's at least one TDC felon.
Well, I'm looking at 4 prior convictions here, and they look like they're in the last 2 are in sequence to the preceding 2. No, he was a Glover Jones.
Yes, sir.
In 25 CR 291. You were charged as you're here with Mr. Kimball, your attorney. You know you're charged with the second degree felony of robbery.
Yes, sir.
But like everything else in criminal law, you are held accountable for the criminal act that's charged plus history, criminal history. Nobody knows better about their criminal history than that person. And you got that 2011 burglary out of Tarrant County. Thereafter, that became final. It says burglary of a habitation. That after that became final, it states you committed evading arrest or detention, a third degree felony, and were convicted of that in Tarrant County in 2013. After that became final, this states you committed the offense of illegal possession of a controlled substance and were convicted next door in March of 22 in the 252nd. So at that time, you were a habitual felon then. And after that became final, it states you committed the offense of illegal possession of a controlled substance and were convicted of that on March 31st. That's the same day, 22. So you were convicted of 2 drug offenses, but you were habitual felon at that time. Now we've got a new case. On or about January 24th of this year, it states you committed the 2nd-degree felony of robbery. And so these past offenses, past convictions are in law never in the past. They always are there haunting a defendant. And this means that if convicted, you're looking at no less than 25 up to life in prison. You understand?
Understand.
You understand?
Attention.
All right. What was going on today?
Mr. Ham tendered an offer of 7 years to count 1, Your Honor. Mr. Glover's refused that. We countered with 3, but Mr. Ham wouldn't accept that. So we're relegated to trial.
Okay.
Is that correct?
That's right.
That's right.
Okay. This is a decision that you got to think about because we're going in this direction or that direction. And if that's the way I work, if you nix the deal, there is no deal. I won't accept it. We're going for what's on the indictment. Everybody understand that. As long as you understand that, everybody gets to make a choice. So that's what you want. You're refusing the offer, the opportunity, and you are insisting on a trial. Correct?
Yes, sir.
All right, it's done. There is no offer. I will not accept anything. That is it. And we're looking at habitual felon if convicted. And that is a choice you must live with. Okay, anything else?
It's just that is a speedy trial.
We're going to do that as soon as possible when y'all can be ready. It looks like that's going to take long. Y'all can be ready. Let's get it done. All right, let's go. No deals. None. Period.
Okay.
Okay.
You want Mr. Lewis?
Where's that?
Back at 1:30 in the trial.
Yeah.
He's number 4.
Yeah, she's going to be on us.
1:30?
Yes, sir.
All right.
Yeah. All right, what else do we? Langston working on some stuff here. Brent, Turk, that's you? Come on up. I thought it was you. We're in trial recess.
Longer.
Paul Johnson, you're Mr. Johnson.
Yes.
Present. Mr. Adams, you're your attorney and the state's attorney. All right. Earlier, you entered a plea of guilty to this 3rd-degree felony of indecency with a child. And a pre-sentence report has been prepared. If the parties had an opportunity to review it, any corrections or changes to it?
Yes, there is one correction. And the correction is on the section that said that he had a pending case out of Louisiana. He informed me that he called and that case has been dismissed. Is that correct from what you told me?
Yes, sir.
That he no longer has a pending case in Louisiana.
Okay.
No.
I think, Mr. Johnson, you pleaded, guilty on
Yes, sir. On June.
June 23rd.
Yes, sir.
You can send that paperwork to Judge.
I sent it.
No, it's in my queue.
Okay.
I'm looking at this.
There's some stuff. You were. Executive Wilson. One thing is, and it was a new building. This race to this kind of burning down. And they really fun. Doing probation.
Look at this. This thing, I can't even write Langston's name in there on the attorney's part. Where's his attorney? Yeah.
I'm writing on it.
Look, write his name. Please.
Yeah, it's got a delay.
Delay, it writes the L and then it won't do anything else.
Yeah, it's just, it was called, that's one of the trial. What's up?
I'll get the message.
Thanks, sir.
Okay. Earlier, you pleaded guilty to this third-degree felony of indecency with a child. A pre-sentence report has been prepared. The parties had an opportunity to review it. Any corrections or changes to it?
Just about that case in Louisiana, he's telling me it's been dismissed.
It won't be considered. State?
As far as I'm aware, that it hasn't been dismissed, and if it has been, I need to check on that.
Well, it's a pending case, right?
Right.
Well, and
you say it's dismissed.
It doesn't matter to this court. The presumption of innocence exists unless you're found guilty of a crime. You haven't been found guilty over there. Okay, so then all that is a pending case. And the pre-sentence report then is made a part of the record for all purposes.
Yes, ma'am. Yes, sir.
All right, the agreement is whatever sentence shall not exceed a cap of 5 years in prison. So this is third-degree felony. We are looking at no less than 2 nor more than 5 years confinement in prison. And regular probation is not an option.
Not an option, only deferred probation.
Yeah, or deferred probation, which can be up to 10 years in length. Okay, go ahead.
Your Honor, one of the biggest things that I noticed in the PSI.
You said time, so thank you.
Is his rating for supervision being moderate, as well as he does not, at least from what I can see, have an extensive criminal history at all. He's a young guy, 23 years old. He did tell me if you give him probation, he will be able to work. And he's currently in a relationship right now with a young lady who's been helping him stay on the right and narrow. Judge, she's asking that you consider giving him the deferred adjudication of probation. He'll follow all the terms, and he also speaks for himself as well.
Yes, sir. My grandma, she being old, you know what I'm saying, and I was her help before I came to jail. And I learned from my mistake, you know what I'm saying, and I'm a better person than I was before. Lots of change about me. I'm ready to get back to my life and get back to working and get back to my relationship with this young lady who's been there for me. I understand what was wrong and what never happened to me.
What did you do that was wrong?
I said, I pulled my penis out.
Okay. Here's the pre-sentence report, okay? And under your version, the probation office writes, they tried to say I showed my penis. They said, show me yours and I'll show you mine. Defendant denies committing the offense.
I did it.
Why would you lie to the probation officer then?
It's just a moment thing.
Sir?
I was just in a little moment thing.
You said he was just in the moment at that time.
You want me to tell you what you said to them? Maybe you forgot.
I read it, Judge.
All right. When asked why you pleaded guilty to the offense, you told them, I'm ready to get out of here. A lot of things going on in my family I need to get back to. But see, look what I did. Those are little asterisks here, which means you're denying responsibility, which you can't do. You don't deny responsibility and then the court accept the deal. I just won't do that. We'll let a jury decide where this should go. That's what happens when something like this happens. What's state say?
Your Honor, he's currently on probation for reckless driving. He got 6 months deferred probation on that, and he currently has an MTRP warrant. I think if he can't make probation on a reckless driving.
That was in 2022.
Right, but he has the active MTRP warrant now.
Oh, they filed an MTRP on it? Oh.
Yes, Your Honor. And if he can't make that deferred probation, I don't know what the chances of his success on a felony sex offender probation would be. And he's been minimizing his involvement in this the entire time. So state is asking for the full 5 years.
Any response?
The response, Judge, is that I understand he got caught to the moment and when he met the probation, but he's accepting responsibility today, and he doesn't have a long criminal history. I think that he's ready to tell you, Judge, if you just give him a shot, he's gonna do right. I mean, I'd rather you say it than me.
I will do right, Judge. Like I said, I'm sorry for what you know what I'm saying. I learned from my mistake, accept my responsibility for what I've done.
What's the status of the child now? Where's the child?
Where's the child? Do you know?
Do you know?
With her father, I believe, Your Honor.
And I believe in the PSI, the dad didn't respond, but you could give any victim input.
How is the defendant? What relationship does the defendant have to the child?
He was living at the house, but he was not related to the child.
Mother, with the mother?
Yes.
The child's mother?
Yes, Your Honor.
I see. Okay. All right. What about this statement in the police court version that the victim stated that other girls in the house were getting it way worse?
I have no idea about that. That I can't say anything about.
You can't or you won't.
I cannot have nothing to say about that. That didn't
So
happen.
she just made that up.
Yes, that didn't happen.
Why do you think she would do that? Because you're the one that made up the first lie. Why are you calling her the liar? You got caught lying.
Well, that it didn't happen. I can own up to this. You know what I'm saying? Well,
Just you're owning up to it. Like when you looked me in the eye during looked the probation officer in the eye on the pre-sentence report and said, you denied committing the offense. I'm just ready to get out of here. So that was a lie.
I wasn't looking a lady in the eye. I was looking towards.
I don't care. Okay, that's just a form of speech.
Yes.
When they're speaking to you and they're doing the report, you lied to them, correct?
Yes.
You did. And that's supposed to inure to your benefit as being forthright
I understand.
and accepting responsibility. Okay. Well, it's not a good thing. Okay, so you when was this plea taken?
June 23rd of 2025.
All right. Let me get to it. Let's get this done. You said June 23rd?
Yes, Your Honor.
I don't have that in the queue.
Judge, I'll send it to you. To the interview.
Okay, yeah, refreshed. Okay. Okay. You're gonna have to we're fixing all this today because you entered a plea of guilty to the indictment here on June 23rd. And then thereafter, the pre-sentence report is prepared. And then the pre-sentence report, your version, where the red asterisks are completely opposite what you pleaded guilty to.
Yes, sir.
You're going to have to fix that.
Yes, sir.
What did you do wrong here?
I pulled my penis out in the middle of playing hide and seek.
That's all you did?
Yes, sir. I knew what was wrong with that when I tried.
All right. What are you asking for here?
Judge, I was asking, I know that it's a bad fine, but I was asking if you get that treatment while on probation. I know that the probation department has a very high successful rate. People complain that he gets those programs that's gonna help him out a lot. That he wouldn't say if he was at TVCJ.
You knew it was wrong.
Yeah.
What state?
We're asking for 5 years.
What would you like to say? Anything else? So,
I just ask that you just give me the chance to prove my work, to prove that I can get better, to prove that I can be a different person. Because with being able to prove it, it'll never be known. You know what I'm saying? I'm asking to at least give me a chance.
Would you agree that indecency with a child or sexual assault of a child, indecency with a child harms a child?
Yes, sir.
And this child was 10 years old, correct?
She was 9.
Says his 10-year-old daughter, she must have turned 10?
Yes. Yes. She turned 10, but she was 9 when that occurred.
Okay. So she was 9 at the time of the event, what we're saying.
Yes. It's in the pre-sentence report too.
March 1st. Well,
It's in the third.
doesn't say her date of birth. Do you know what her date of birth is? You don't, okay.
It's June 9th of 2013. She would have just turned 10 when it was reported.
Okay, that's what happened in the interim from the event to the time it was turned in. So she was 9. All right. You agree children are harmed when this happens. And the only problem is when do they get over this harmed? Never. It's always in the back of their mind. It's always haunting. That's why adults have a very special responsibility not to harm a child, because that sends them in a direction that's not their fault. The child, it is serious harm. That's why you never hurt a child, and because they carry with that. It's always in the back of their mind, even when they're elderly people. It's an event that haunts them, and that's why you don't want to cross that road, because you can't undo the harm to a child. Can't erase it from the memory. So it's there. In this particular case, Mr. Johnson, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty.
Yes, sir.
There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this second-degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You will be given credit for time you have served. I'm looking at 550 days. So you may have already been satisfied with this time that has been served. The one thing that this court always stands for is helping the victims try to repair the harm to them, as well as making sure that defendants are treated fairly. You were looking at up to 10 years in prison for this, up to 10 years in prison. And the legislature felt there's circumstances where 10 years in prison is appropriate for indecency with a child by exposure. A child should not have to go through life recalling in their memory, because they do, and their childhood, that their childhood was harmed by this terrible event that they can't undo. You can't undo the harm. It's there forever. That's why it's important you not harm the child. And that's why when people do harm children, they pay a price that's steep. You're going to, with this conviction, you have the responsibility of also registering as a sex offender. And the sex offender registration is before the court as well. And it looks like all parties have signed it, and you must realize that you have a reportable conviction to register in the sex offender registration program. You have signed this. This begins this registration that you're going to have to follow. And I can't tell you if it's life or if it's 10 years.
10 years
It's
for
10 years.
exposure.
So failure to comply properly with the registration program is a criminal offense that can result in prosecution. So you have to make sure that you register. You are registered during this next decade. If you move to another state that has similar reporting requirements for sex offenders, you must register in that state. Failing to do so can result in you being charged with a criminal offense. Do you understand your responsibilities here, sir? All right. Anything else on this?
That's it.
All right, anything from the state?
Nope, Your Honor.
That is all. Thank you. Who's next?
I can do Mr. Isaac if you want.
Jeremy, Isaac, please.
He'll have to have fingerprint in front of me, but.
And then Stocks is done too.
Oh, yeah. I haven't noticed.
It's gonna be perfectly Stocks, Isaac.
Isaac, I need to print.
Let's see, what till we Stocks then?
Do what?
When we get Stocks while you print Isaac.
It doesn't matter.
Yeah, no, Isaac's good.
It won't take me but 2 seconds to print them.
And then after that is Stotts.
And after that, it's gonna be Stocks. He's done.
Stotts. Come on up. You're Mr. Isaac? See that lady first. Thank you.
Raise your right hand, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
That's fine.
Keep your right thumb front. Yep. Place your hand. One more time. Perfect. Okay, let's see Judge.
Two cases are called 40991 and 40992. This is 22 prefix on each of these. The state of Texas versus Jeremy Isaac. That's you.
Yes, sir.
Present with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive formal readings of these indictments and the arraignments here? Can we proceed in summary?
Yes, sir.
Okay. These are both state jail felonies. In summary, each of these similarly state that in 40991 on or about May 2nd, 2019, and in 40992 on or about May 20th, 2019. Both stating in Jefferson County, Texas, you committed the state jail felonies of burglaries of buildings. Do you understand what you are charged with in these cases?
Yes, sir.
Look at some.
On each of these indictments, Judge, you'll need to do 2 additional paragraphs because we're pleading as a third-degree punishment.
Do they need to be in sequence?
Yes, sir.
No. They're all state jails, right?
Yes, sir.
Okay.
Oh, let me confirm to make sure. If you do counts 2 and 3, that they're the same in both indictment, Judge.
All right. And for state jail felonies, Mr. Isaac, if convicted, you are looking at no less than 180 days, no more than 2 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Because of your prior convictions, though, the punishment range can be enhanceable. And paragraphs 3 and 4, is that right? Or 2 and 3?
I said 2 and 3, Judge. But
The possession of that's possession of control, so 07. And then 3 is burglary of a state, no, theft. I'm sorry. Possession of a controlled substance. And then number 2 is theft, 2015. Good. Paragraphs 2 and 3 similarly state in each case that you have prior convictions. In paragraph 2, in each case, you were convicted on September 17th, 2007 in cause number 7-1484 in the 252nd District Court of Jefferson County, Texas, for the felony state jail of illegal possession of a controlled substance. And in paragraph 3, it similarly states that you were finally convicted in each case. States in paragraph 3 that you were finally convicted on June 8th, 2015 in the 252nd District Court of Jefferson County, Texas, in cause number 15-21882 for the state jail felony of theft. Do you understand paragraphs 1, 2, and 3 constitute a state jail felony, but it is punished as though it were a third-degree felony? If all of this was true, do you understand?
Yes, sir.
So therefore, you're looking at no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
This isn't going to be an easy one here.
Hey, excuse me, Judge Stevens.
Yeah.
I seen you in 2022 and you gave me 7 years for felony theft. And from my understanding, you told me any cases after I signed for the felonies that I was accused of, they would be ran CC with my time. Because I'm on bench warrant right now. I'm on bench warrant right now from Styles. And I haven't been out since 2022. But I just made parole. And as soon as I made parole, the DA picked up 2 cases from 2022.
Okay.
And I've been locked up since 2022. It's like 4 years ago.
Okay.
I put the plea work there.
Should I get all that back time, because that's not my fault.
Yeah, it's not and it's not mine either.
Yes, sir.
The time credit is always the responsibility of the executive branch of government, not the court. The court makes its findings and sentencings, and if I run things concurrent, they run concurrent.
Yes, sir.
It's not for me to fix that because I lose jurisdiction of the case. But you don't get for the rest of your life, I can commit crimes and it all runs concurrently with those early cases. That's not going to work. That's never worked.
Yes, sir.
No judge would say, yeah, whatever is in the future, you don't have to worry about that. Commit crimes, it'll all run concurrently. No, generally you have to be held responsible for each crime. You take each group together at the same, when we're in court, if it's packaged in the same proceeding, then if it's going to run concurrent, it will run concurrent. And if it doesn't, you have a legal remedy to handle that. And it's not through me because I lose jurisdiction of it when it's final. It goes through the executive branch and then the attorney files some kind of a proceeding stating, asking a court to mandamus the sentence. But these new sentences aren't going to run concurrently except with each other. I guess, right? That's what's normally done. But as far as running, I would never say, you're wrong. I would never say, oh, whatever you're going to have, whatever you're going to commit in the future, it'll all run concurrently with this. No, that's not what happens. That would never be. I mean, why would I do that? I mean, if I were a criminal, I'd go, good. I can commit crimes for the rest of my life. And I'm going to be a terrorist and it'll all run concurrently. That doesn't make any sense. That's not the way the law is. And I wouldn't have said that anyway, but I got a worse problem. This thing ain't working. This pad is not working. I can't, I don't want this pad. We're spending too much time. See, I just hit the open and it's just sitting there. It's not moving.
Okay, sir.
Give me something else that works. Yeah, we could be here forever. Look, I see, this is what I'm doing, trying to open the thing. Okay. And nothing. Okay, open. Nothing.
Just give me a second, Judge.
That's been giving us trouble all morning. Langston's fault.
That goes without saying.
Somebody's knocking.
You doing anything off today?
I want to see it last Thursday. They had taken off. I mean,
So it's reset or?
yeah, it's not, I can't even talk with her right now.
Okay, what's our plan on this?
On this case?
Yeah.
This case, 7 years.
Correct.
All right.
All one confirmed.
Is that your understanding, Mr. Isaac? You're going to be pleading guilty to the burglary in each case, and then paragraphs 2 and 3, the prior convictions, and it's a state jail felony, punished as though it were a 3rd-degree felony, but it will say state jail on the paperwork. So, understanding that punishment range is enhanced because of the prior convictions, the agreement is you would be placed pleading guilty to the state jail felony, punished as though it were a 3rd-degree felony, and sentenced to 7 years in prison to run concurrently. Is that your understanding of these agreements?
Yes, sir.
Okay. If I follow these agreements, you have no right of appeal of your cases. Do you understand?
You want to have me right of appeal? Right.
He's nodding. Yeah. So how do you plead in each of these indictments, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Because I'm guilty.
And voluntarily. Nobody's forcing you, right?
Right.
And these 2 prior convictions in 2007 and 2015 in paragraphs 2 and 3 in each of these indictments, are those allegations of prior convictions true and correct as they are alleged?
It's true. True.
And are you pleading true and correct to those allegations voluntarily and because those allegations are true?
Yes.
Whenever the pad comes up, I'm going to show you here. Yeah. What's marked as States Exhibit 1. And I'm going to ask you if you sign those documents voluntarily. And are those documents true and correct
Okay. That's
You don't work? Yeah, it's not working. Unhandled exception is occur on your application.
You want to just do it on paper? Do paper? I think we still got the gold paper on. Okay. Scan. Oh.
Look, now, here's what it's doing now. That's convoluted. I need somebody from MIS down here to explain why we can't, if we can't work the pads, we can't do our business. Yeah, this stops everything we're doing.
Back. I don't know how to fix it.
Thank you. It's a new set of pads and they're not working as they should.
Let me know about, she has some new charges coming from.
You're talking about Jalen?
Yeah.
Oh,
That right, Jimmy?
what do you want to do today?
Well, when I went out to the jail to visit her on Thursday, what I want to do is just reset it because
for how long?
I think she needs to see me perform again because they had separated her out of the dorm and her condition is getting worse.
What do we need to do?
I would say let her go back and see me performing because he had already found her incompetent and we was trying to, get her back. I had it right, Jimmy? Mr. Ham.
Okay, so she's being found incompetent.
She was.
But she regained competency and then we released her on conditions. And she's accused of having assaulted and threatened the person that was her caregiver.
That was her character. And then when I went to the jail to visit her on Thursday, with today being Monday, they had to take her out. And they said that the state in the court can call the book in and confirm this. And I don't want to misspeak, but to my general understanding of it is that they had to take her out of the dorm because of some issues that she was having mentally. And I wasn't able to visit with her.
So what are you asking?
I would actually send her back to Rapon because, and if you want to pull out and see, I would suggest send her back to Rapon.
You mean with all my expertise as a psychiatrist?
With all your expertise as a psychologist, let's see what you.
She got a limited competency return. It resulted in us giving her conditions of release that were approved. We had folks here and
that's true.
It was very detailed. So,
well, but I mean, it's either competent or incompetent. There's no. You don't get a C plus competence. It's competency or incompetency. That's the test. There's a scientific test for it. And a legal test.
4 weeks and I see if I can figure something out.
It's one or the other. It can't be.
Yes, sir.
I know we call it borderline, but one day they're not.
She was extended for outpatient commitment. It was considered at that time by the last reports, Judge, that you had, that she was still incompetent to stand trial. She was released to basically at home commitment because they didn't want to do inpatient commitment anymore. So we did a structured plan under 46B 071 and 072 that resulted in her being released to her grandmother. That grandmother is now the victim of the alleged victim on the new offenses that occurred in June.
So what do we do?
And what I'm saying is it's gotten worse because when I
what do we do?
jail, that's why I was suggesting that.
So how do you undo the assault? I mean, we got to deal with that, right?
Yes, sir. But right now they're misdemeanor offenses that didn't get.
Nonetheless, I mean that.
I'm just informing the court.
Do I need? Well, what direction are we heading in?
I believe that
the community.
Well, since our last report is January 14th of 2025, I'm going to agree with Mr. Adams that we're going to need to have somebody see her again, because I think we're going to need to send her back for inpatient commitment so that we can regain competency to resolve these things.
Dr. Rapon will be ordered to reevaluate her. She is in custody right now.
Yes, sir. We're all safe for her at the moment.
That will be ordered.
All right. The next one, Judge, is with Mr. Shadran, I believe, and I have that one with Daniel, Mr. Boyd.
What kind of hearing is this?
Well, what happened was we initially had a plea deal, but when you talk with him, he was talking about the FBI and needing to see the FBI, and he wasn't all right. I filed a motion to have him tested, and then I went to go visit him on Thursday too. He still was talking about some FBI stuff I couldn't communicate with him. And then I went back today and tried to talk with him again. And I mean, like I said, if you want to see if you can get through him in a way that I can.
You filed a motion for competence?
Yes.
Okay.
To have him tested.
I'll sign it. Your word's good enough for me. Thank you.
All right.
Yeah, it's in the file, I guess.
It should be in the file. Mental illness. I think I filed one, if I'm not mistaken.
I don't have one in here.
If you don't, I'll get one to you.
Yeah, like, so if you could just email.
I do it today.
All right. Dale Damon.
He is not
He's
here.
in PDCJ.
He's
He's
not here.
been forwarded to a different county, but he's not here.
Jeremy Isaac.
That's this guy
That's
right
he done the plea
here.
right now.
Judge, I got this
Finally.
office to go away if you want to try to finish the plea while we wait on him.
Yeah, we done the plea right now.
What are you going to do with Stotts?
That's another plea ready for you right now.
And
That's it.
I think there's something. See if we can change our time Friday.
okay, this agreement in these two cases, Mr. Isaac, it states that you would be sentenced to 7 years in prison to run. The sentence will run concurrently with 22-40992. And in that case, you will be sentenced to 7 years in prison to run concurrently with 40991. Those two. All cases will run concurrently. with other cases that you have, right?
And TC.
It says all cases will run concurrently with. I can't understand. What is this word? What is this word?
Let me see. Uh-oh, let me put my glasses on. Oh, will run concurrent with existing TDCJ cases. So he has existing TDCJ, which is the felony.
Okay, it runs concurrently with all of the cases that have been disposed of.
Yes, sir.
I'm going to follow this agreement, and thus you will have no right of appeal of your cases. Do you understand?
Yes, sir.
So in each of these cases, again, how do you plead in these indictments for state jail felony of burglary of a building? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
And paragraphs 2 and 3 in each case, which allege prior state jail felony convictions out of the 252nd District Court of Jefferson County, Texas. Are those true and correct as they are alleged? And are you pleading true and correct to those voluntarily?
Yes.
And this constitutes a state jail felony punished as though it were a third-degree felony.
Yes.
In each of these cases, I show you what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection. Admitted. Among other things, this states you are mentally competent. In each of these cases, you are mentally competent to enter your guilty pleas. These are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And again, you have pleaded true to the prior state jail felonies as alleged in paragraphs 2 and 3 on each indictment, and those are true and correct as they are alleged. Thus, you will be sentenced as a state jail felon, punished though as a third-degree felony. I am following this agreement. You have pleaded guilty voluntarily, knowingly, intelligently, and you understand the agreement. If I follow this, will be 7 years in prison in each case. Is all of that true and correct?
Yes.
Thus, I find you guilty of the state jail felonies in each of these cases. Paragraphs 2 and 3 are proven true beyond a reasonable doubt. Thus, you were punished as a state jail felon, punished as though it were a third-degree felony. I'm following these agreements. You are hereby sentenced in each of these cases to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 7 years in each case to run concurrently. You understand what has happened today?
Yes, sir.
Anything else on this?
That's it.
Thank you. That is all on this one. See, there's a problem that I have, as most left-handers. When I write, I write this kind of, and any pressure I put on these pads, these new pads, they come out as blemishes and marks.
It shouldn't, which tablet are you using?
I gave him one of those over there.
It shouldn't, and if you write your hand, if you write your hand on it, it couldn't do it.
I'll show you. Well, I'm gonna write normal here. And now this thing is coming up. A block is coming up. Restore, minimize, close.
Tap the pen where like in a gray area where there's no document. Yeah,
It's and watch. I'm gonna watch them. Punished as third degree felony. Okay. Nothing's happening. And this box keeps showing up.
Yeah, I think it's your hand maybe hitting.
I know, that's what I'm saying. But that's the way I write. I can put something over this, but that's just.
No, I'll there's a setting I can change on. I can change on that for you.
I can do this. That's a way to do it. It's like the old days when I was in Catholic school. You had that thing that you rested your arm on, but it was we had no left-handed desks. You had to rest your right arm. There was nothing to rest. So the only way you can rest your hand is to turn clockwise. And it was on the top of the desk. And that's why left-handers write backwards in that generation. The old days. Okay. I think we've taken care of those two. Thank you. That is all.
And Mr. Stotts is the last one.
Victor Stott.
You can sign it up too.
Here we go. Thank you. I have 4 cases on Stotts. How many is he pleading for?
3, Your Honor, and then he was going to be continued on probation, and the 4th one and the restitution was going to be added.
He's back. Come on, Mr. Stotts. But I'm looking at 3 cases. So which one are we going to continue?
This one now, see if it's any better.
We're figuring out how to work this one.
We're trying to help you out, Judge.
It shouldn't pick up his hand whenever you write either. So
which one is going to be continued? What number?
Oh, it'll be 23-41457.
Okay, that will be continued. So I'm going to be calling 23 CR 347, 345, 347, and 349.
That's correct,
3 cases. Okay. And you are Victor Stotts?
Yes, Your Honor.
Your attorney, Mr. Adams, does the defendant waive formal readings of these motions to revoke probation? And we proceed in summary. Yes?
Yes, sir.
Raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing on these motions to revoke probation will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Lower your hand. Each of these similarly state, and we're talking about cause numbers 23 CR 345, 347, 349. And which one is going to be continued, did you say?
41457, Your Honor.
And 41457. And let's take these first 3 first. Again, 345, 347, 349. In summary, each of these similarly allege, sir, that on June 5th, 2023, in this court, you were sentenced to 2 years in the state jail, probated for 5 years on each case for burglary of a building in 345, another burglary of a building in 347, and fraudulent use or possession of identifying information in 349. Is all of that true and correct?
Yes, Your Honor.
Allegation 1. In each of these cases states that you failed to report to the probation office on or about June 5th, 2023 in violation of your probation order of reporting property. Is that true and correct?
Yes, Your Honor.
Did the defendant abscond?
Yeah, yes, Your Honor. That's correct.
Okay. From June 5th, 2023 until when? When were you arrested? This year?
Last month.
Last month?
On the 22nd of last month.
June of, so he would have been gone for 2 years.
Right.
Is that true?
Yes, Your Honor.
Okay. Is that the only one we need?
Yes, Your Honor.
Okay. Are you pleading true voluntarily, knowingly, intelligently to failing to report as required and being an absconder for 2 years? Are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
You understand that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant the motions to revoke probation. Your probations can be revoked. And you, since you were already found guilty and placed on probation, you were looking at these cases as no less than confinement, no less than 180 days in the state jail, up to 2 years on the state jail in each case.
Yes, sir.
Knowing that, do you insist on pleading true in each of these cases? I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. It's marking on the tablet again. I don't know what you're giving me, but it's still doing it. When I press down on my with my, and I can't find the other sliders. This is it. Yeah, I can. Oh, see, I can't. And then see, it's where I'm pressing down here, it's smudging right there.
Are you on the?
I've got nothing. See, nothing's working on this right now.
It may be delayed too, Your Honor, like ours, when we're signing our name, it won't.
Yeah, we're trying to replace y'all. We'll replace you
Okay.
in October.
Well, all I'm trying to do is look, okay, you see, I'm gonna just what? That's. This is the. You see, it's.
Can I see for just a second, just? I'm sorry.
Agreements have been reached in each of these cases that, what are the agreements?
Yeah, 180 days state jail, Your Honor, on 4-5, 4-7, and 4-9 to run concurrently.
Is that your understanding of the plan, sir?
Yes, Your Honor.
And then also, Your Honor, to be continued on probation in 41457, and the restitution added from $7,000 from 4.5 to the 41457. That's the second degree felony. And then $1,500 in restitution also to be added to 41457, the second degree felony.
Is that your understanding of the plan?
Yes, sir.
If I follow this, you have no right of appeal of these cases. Do you understand?
Yes, sir.
Show you what's marked as State's Exhibit 1 in each of these cases. Did you sign those documents voluntarily? Understand them, discuss them with your attorney, or the contents all true and correct?
No.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states if I follow this agreement, you have no right of appeal. I'm going to follow this agreement. Do you understand? All right, if nothing further, I'm going to find there is sufficient evidence supporting these motions to revoke probation in 345, 347, and 349 to grant them by a preponderance of the evidence or greater, as allegation 1 has been pleaded true to voluntarily, knowingly, intelligently. Thus, your probation is for that state jail felony in each of those cases is revoked. And following this agreement, you are hereby sentenced to confinement in the state jail for a term of 180 days in each of these cases to run concurrently. You understand what has happened in each of these 3 cases?
Yes, sir.
Now, we're going to go to the final one. In 23-41457, does the defendant waive a formal reading of this and motion to revoke probation? Can we proceed in summary?
Yes, sir.
In summary, this states that on June 5th, 2023, in this court, you were sentenced to 10 years in prison, probated for 10 years for engaging in organized criminal activity as second-degree felony. Do you understand what you're charged with, and is that allegation true and correct as it is alleged?
Yes, sir.
Allegation 1 states similarly as the other cases that you failed to report to the probation office as required on or about June 5th, 2023 in violation of your probation order. Is that true and correct?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
You understand that a knowing and voluntary made plea of true to 1 or more violations of probation, that is enough to grant motion to revoke probation. Your probation can be revoked, and
And I sent, Your Honor, I sent the dismissal on that one because it's into being continued.
That's the way you give.
Yeah, there's a little bit of a delay sometimes. I don't know why it does that. These talents. The Dell ones are powerful.
Okay, in 23-41457, you have pleaded true voluntarily, knowingly, intelligently to allegation 1. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. However, what's going to happen here is we're going to continue you on this probation. We must amend, though, the terms and conditions of probation to add the
$7,000 in restitution from 345, Your Honor.
the restitution to the appropriate party in 4-5.
Yes, Your Honor. There was $7,000 to a Michael Mudd from in 4-5.
And in 4-7,
there was $1,500 to a Denise Birdwell.
Those restitutions shall be applied within cause number 23-41457 as a condition of your probation as restitution from those cases transferred over to this case. Do you understand? So you resolve 3 of the cases with sentences of 180 days, and then you will continue your probation in this motion to revoke probation. It will be continued, and we will review it every 6 months or so to see how you're doing. Okay, we'll review this in 6 months. All right. So do you understand what has happened today? 3 are resolved and 1 is amended for these additional restitution, and you will be continued on that 3rd-degree felony. Be careful. If you fail, your probation could be revoked and you could be sentenced up to 10 years in prison. All right. Do you understand what has happened today, sir? That's all. Thank you. You know, I have this on this last case, there's this motion to dismiss the motion to revoke probation. And I'm not sure that's what we want to do because I've continued him. But if we dismiss it,
yes, Your Honor,
then I don't think it makes a difference if it's dismissed. He'll continue on probation.
Right.
The motion is dismissed, not the probation. But we need to do something bookkeeping wise and by order that I have to sign, which amends his probation to include those 2 restitutions.
You've already signed it, Judge.
Okay, then it'll be applied. Okay. So any objection to me just dismissing this motion to revoke probation?
No.
Okay. All right. It's 41457 is hereby dismissed.
Thank you, Judge.
Okay, thanks. Yeah. Okay. What else? Langston, did you?
That's it. I think I got all of mine.
Okay. I've got a Jalen Bob, which we did. Then I've got Jeremiah Chadra, and I also have Dale Damon.
Thank you for that.
Then we never saw David, huh? Okay. We are in recess. Thank you. We'll be picking a jury here this afternoon.
Having issues. I'll recall that bond forfeiture. Mr. Garcia, were you able to get someone hired?
I know I wasn't, but I am waiting on 1 call back. I made a few calls, but everything was not too expensive, to be honest.
Who'd you talk to?
I talked to David Boyer,
Chadwick Roberson, Herman Martinez, and I'm waiting on a call back from Jamal Johnson. I have a few other lawyers that I called on here, but they were just too much.
Okay. And you're working?
Yes, ma'am.
Okay, so I'm gonna give you one more reset. You need to try to keep, as you can tell from talking to them, they all charge different amounts.
Yeah.
Talk to at least 3 more, if not more than that. See if you can get someone hired before that. So I can't recommend attorneys. I don't know some of those names that you were talking about. And so some of them might be from out of town. My suggestion is typically an in-town lawyer would probably be more reasonably priced. Google criminal district defense attorneys in Jefferson County. You're going to get a list of them that I think is probably different than that list.
Well, this is the one that gave me for Jefferson County on Google.
Okay. You also can walk across to the Bar Association. It's right across this lobby, the Jefferson County Bar Association. They have a criminal referral program, and they can give you a list of 3 attorneys. So when you leave here today, walk straight over there. There's a door. You just need to knock on that door, and it's right here straight across. When you walk out this door, go straight across to the other side, and it's on this floor. So I'm going to give you another 30 days to see if you can get someone hired. Okay? Step in front of the clerk. Right here. Using PCP 2 weeks ago. Is that correct?
Mm-hmm.
How'd you get here today? Answer out loud. Okay. Stand right here. So obviously this is a violation of your bond conditions, and it is not safe for me to have you out while you're on bond for a felony using PCP, benzodiazepine, all this stuff. When's the last time you smoked marijuana and used benzo? So pretty much had a big party 2 weeks ago, used it all?
Depression.
The pressure of what?
Depression.
Depression?
Yes, ma'am.
You do understand that all of these things makes that worse, not better.
Yes, ma'am.
Do you have a doctor that you're going to?
From, I don't know what happened to him. I just found a new doctor. I was.
Hold on a second. If you want to see if your client can get back real quick, we just reset it just because it had gotten so late. But if he just left, if you want to try to call him or have your office call him, if y'all want to take care of it with the plea today, we can do it.
Let me try to get it right now.
Okay.
See if I can get him on cell phone.
Thank you. Okay. I don't believe that the last time you used was a couple weeks ago. You're not coherent.
Yeah.
Hang on.
Yes, ma'am.
So what, Ms. Washington, I'm going to, hold on, let me find, what was her bond set at? Can y'all tell real quick for me? Nope, I got it. I'm finding it. I'm going to find that you violated your bond conditions by using all of these substances. And I'm going to raise your bond at this time, find that you're at large without, or based on those bond conditions, raise your bond. This shows 6,000.
6,000. It is 6,000.
All right, I'm going to raise your bond to $15,000 in your case. A condition of that bond, if you make it, is that you have to wear a drug patch. You have to have that drug patch put on within 24 hours of your release and give proof to that to your bondsman. If you test positive on that drug patch, you're going to be right back in jail with a much higher bond. Do you understand? Go back with the bailiff.
Do I get the drug patch?
Your bondsman can tell you where to get it.
Okay.
Good morning, all those who are going to testify, raise your right hand. Let's place you under oath.
All right, Miss Chansey, Miss Breeley here.
Is that microphone on, Officer Hall?
There we go.
Okay.
You step up here. Miss Breeley here is 15, so I'll ask her the standard questions,
All
Judge,
right.
and I have a consent form. You're Breeley Chansey, is that correct?
Yes, ma'am.
And you're 15 years old?
Yes, ma'am.
And you understand that your stepmother here has filed a petition along with your dad to ask you to be adopted, is that correct?
Yes, ma'am.
And do you understand that the court does this adoption, you'll become her legal child for all legal purposes?
Yes, ma'am, I do.
And you understand that while you're under 18 years old, your mother here and your father here would have decision about whether you'd have any contact with your birth family?
Yes, ma'am.
Okay. Do you understand that you would inherit here from your mother here and your father here and not from your biological family?
Yes, ma'am.
Is anybody pressuring you to agree to this adoption?
No, ma'am.
Do you believe this is in your best interest and want
Yes.
it to happen?
Yes, ma'am.
Do you freely and voluntarily, without any pressure from anyone, consent to your adoption today?
Yes, ma'am.
All right. You need to click yes on that box there. Print and sign the next. Yep. You can. Just like that. It's you. Perfect. Let your dad step up here and I'll pass this up to the judge. You are Mitchell Thomas Chansey, is that correct?
Yes,
And this is your daughter Breeley, who just appeared before the judge, is that correct?
yes, ma'am.
And is this a copy of her birth certificate and the putative father registry showing that you're the only father?
Yes, it is.
Judge, we'd offer that as the first exhibit. The next exhibit. You're her father and you've raised her your entire life, is that correct?
Yes,
And you are married to your wife that is here with you today, is that correct?
yes,
And you're divorced from the biological mother, and this is a copy of your divorce decree, is that correct?
that is correct.
And is this a copy of your marriage certificate to your current wife?
Yes, ma'am, it is.
Judge, we'd offer those as the last exhibits. Do you understand that if you ask the court to approve this adoption today, it will create the legal relationship that your wife is equal in rights to you to this child?
Yes,
And you understand that if you would separate or divorce, you could have to pay child support or custody between the two of you regarding her needs.
yes, ma'am.
Are you willing to share those responsibilities?
Sure.
Are you asking the court to approve her adoption today by your wife?
Yes,
All right. And if you'll step up. You are Brittany Page Chansey, correct?
Yes, ma'am.
And you are stepmom right now, correct?
Yes, ma'am.
And you've heard your husband's testimony, correct?
Yes.
Do you agree with the statements he's made?
Yes.
Do you understand if the court were to approve this adoption today, it's going to create the legal relationship that Breeley was born to you,
Yes, ma'am.
that she'll inherit from you,
Yes, ma'am.
and that you're going to be equally responsible with your husband for her financial, educational, spiritual care, anything she needs going forward.
Yes.
In the unlikely event that you two would separate, you understand you have to pay child support or there'll be a custody order for her needs.
Yes.
Are you asking the court to approve the adoption today
Yes, ma'am.
and legally establish you as mom?
Yes.
And I didn't ask all three of you, but all three of you were keeping the name the same, correct? Those are our questions, Judge, and I have a
All
final.
right, my job is to make sure that Mrs. Chansey understands completely her obligations that she's assuming. Right now, you're a step parent and Breeley may be your stepdaughter, but you have no legal obligation to provide for her to take care of her. And she conversely has no legal obligations towards you other than treat you as a step parent. But if we enter this order today, that changes and she becomes your child the same. And I know this has been explained to you, but it's the same as if she was your biological child. And that means that when you get old, she has to come and take care of you and, you know, and so forth, instead of putting you in a nursing home like some people would do. And that also means that you got to provide for her and you got to talk to her about the boys that she's going to start dating probably any day and make sure that she only goes out with the ones that you approve of. Really, you understand that she's going to have now a veto power over who these guys are that you're going to go out with, right? And that's okay with you. She apparently has good taste because she chose your father, so that may speak volumes. So everything is in order. I'm happy to grant your adoption. So
Thank you. I got to meet this young lady out there today, and she's got some pretty admirable aspirations for when she graduates. You want to tell
what are your, step up there and tell me what your plans are. So.
I want to go to college after high school and become a speech pathologist.
A speech pathologist, well, that's great. There's certainly something that I think there's a need for.
The same judge as many children I deal with in foster care. It's an admirable position. It's in high need. All right, Judge, could they stand before you and get a couple pictures?
I'm sorry.
May they stand in front of you and get a couple pictures? If you guys want to go over there and stand in front, I'll take your picture with Judge.
Come on up.
Yeah. Oh, y'all can come up there. All right, follow around with the officer tells you to.
We'd let you sit in the tree. Slam together. Congratulations. As a memento. Hopefully they'll make it a special day for you. All right. Colin, with that file. Everybody come on up here. Whole crowd, come on. Anybody that's associated with this adoption in the matter of Gabriel Augustus Tabor that wants to be involved in this, come right up here. All right, everybody that's going to actually testify in this case needs to raise your right hand and let us place you under oath. Right.
Would you state your name? Ashley Gillette. And
Except if you will, I have a little bit of issue with trying to make sure I can hear everybody and that we're recording everything. So just step in front of that microphone.
Ashley Gillette.
All right.
And are you the foster mom of this young man?
Yes, ma'am.
And how long have you been there for his foster mom?
His entire life.
His entire life.
Since he
So
was 5 days old.
5 days old. Oh my gosh, you've had him a while. So you understand him and you're bonded with him.
Yes, ma'am.
He's part of your family now.
Yes, ma'am.
And you want to make this legal, correct?
Yes.
And do you understand what adoption means?
Yes, ma'am.
He will be yours, just as if you gave her. I know.
Officer Howell.
And you want to, apparently you want to do that.
Yes, ma'am.
Okay. Would you state your name, please?
Travis Harrison.
And Mr. Harrison, you heard what your wife testified to?
Yes, ma'am.
And do you feel the same way?
Yes, ma'am.
You're ready, willing, and able,
Yes, ma'am.
correct?
Are you crying too, Gabe?
And would you state your name, please?
Yolanda Cole standing in for the little
And are you DCS?
Yes,
And does DCS presently have guardianship? And does DCS? That's it.
All right, I have reviewed the file and all of the necessary termination of parental rights have occurred. Mr. and Ms. Gillette and Mr. Harrison, both of you understand that the obligations you're assuming are permanent. That in other words, when you're a foster parent and problems arise with a child, you can always contact DCS and assume return the child. In this particular situation, we're going to be making this a permanent relationship. They're going to be the same as if he's your biological child. And you won't be able to take him back to the Department of Children's Services when he misbehaves or does something you don't like. Both of you understand this is a permanent arrangement and you're both willing to assume that obligation. Is that correct? Most of the time, Ms. Gillette, when I have people crying in my courtroom, it's not because they're happy, it's because of the opposite direction. So. All right, I have signed your order and granted your adoption.
Yes. Okay.
All right, y'all want a photo? You want to just
Yes, please.
Yes.
have the whole group or you want the, we got Spider-Man and we've got Superman here. I don't know who else is any other superheroes. So. Tell you what, y'all coming up here first.
Okay.
Come up here.
One, two, three. Perfect.
Superman. We got another little boy. Let's see what that That's the old one, because that wouldn't work, yeah. It wasn't working earlier. All right, go back to the first case. All right, good morning. Everybody that's going to testify, let's raise your right hand and place you under oath.
Yes,
Name, please.
Ashley Hooksima.
And you are presently the foster mother of these 3 babies, right? And how long have they been in your home?
Since February 16th of 24.
Okay, so you've had them a while.
Mhm.
And you've made the decision that you.
Yes.
And do you understand that adoption means they were, it's as if they were born? Responsibility and joy, correct? State your name, please. Yolanda. And are you a representative? And does the department presently have guardianship of these children? That's it.
Well, I've looked at the file and everything is in order. All of the proper termination of parental rights have occurred. I frankly don't know which is greater, your compassion or your courage to adopt 3 young children at this age. But certainly you have my admiration for the fact that you're willing to assume this responsibility, and these children are lucky to have somebody who's willing to step up and take care of them in that way. So I'm happy to grant, you understand this to be a permanent arrangement. It's going to change the nature of your relationship with these children. They will no longer be your foster children. They will be your children, the same as if you had given birth to them. You understand that? You're going to be a single parent, is that correct?
Yes.
And you're willing to do that for 3 small children and all of the obligations. I understand there'll be some financial.
I've already raised 6 by myself, so.
Wow. I've not seen many people who have your grit and determination, not in this day and age anyway. So. Uh-oh is right. All right, congratulations.
Thank you.
You have triplets, so
I think they would like some pictures too.
that is fine. Why don't I, since we have a crowd, I'll come, Ms. Smith, I'll come down there. So, you want to just do it there, or you want to come up here? Come on.
You want to say it?
Y'all want to go up there? If y'all wait, let
We're
the
gonna get
rest
them in
of
the front.
your other 6 children.
Just kind of spread, yeah.
Anywhere
Just kind of spread out. All
of these.
You need.
Hey, cheese.
All right. This is the motion for default judgment.
It is, Your Honor, and if Your Honor would, I'd like to just go ahead and finalize the whole thing today.
All right, all those who are going to testify, raise your right hand, please. Let's let you be placed under oath.
Yes.
Yes.
And I'll begin with Hope. If you could just please state your name for the court.
Hope LaFrance,
And what is your relationship to Savannah Halsey?
mother,
How long has she lived with you?
June 2016.
Okay. And you have custody of her through juvenile court? Is that
Yes.
So she was a month old when she came to live with you?
Yeah, I have her siblings that have already been fully adopted as well.
And during the time that you've had her, have any of the parents paid child support or anything like that?
No.
Have they, when was the last time either parent visited?
Never.
Have you heard from them recently?
Not, probably about a year ago actually 2 years ago when we were trying to start this process of just getting it all finalized and just trying to figure out where to serve her and those kind of things. But it wasn't a conversation of, hey, let's come hang out.
Has she called to ask about either parent called to ask about Savannah?
No.
And you referenced it a little bit earlier. Do you even know where they live?
No.
Do you have reason to believe that they've been in and out of jail since you've had custody of Savannah?
Yes, we've had to serve her multiple times during this process in jail.
And what does Savannah call you guys?
Mom and Dad?
Does she have any relationship at all with either parent?
No.
And are you guys wanting to adopt Savannah today?
Yes.
Do you understand that if the adoption is granted, it will be as if she's your biological child?
Yes.
She will have inheritance rights and you vice versa. Do you understand that if there's a divorce, one of you could be responsible for child support?
Yes.
Do you understand, are you financially able to care for Savannah?
Yes.
And you're requesting that her name be changed?
Yes.
To what?
Gracie LaFrance.
And you had mentioned other children in the home. Are these Savannah's biological children?
Yes.
And you've adopted them previously?
Yep, they're many years ago. Judge Wolf.
Oh, wait, you're a repeat customer?
I am. I liked you so much the first time, I decided to come back.
Well, good.
And then, Mr. LaFrance, if you could just, I won't have you run through the whole thing, but are you wanting to adopt Savannah?
Absolutely.
And you understand that it will be as if she's your biological child,
Yes.
and she will have inheritance rights from you and you vice
Yes.
versa.
Yes.
If you divorce, one of you could be responsible for child support.
Yes.
Are you financially able to care for Savannah?
Yes.
And you're requesting her name be changed also?
Yes.
And Your Honor, I got a little ahead of myself. They were served quite some time ago. And
I looked at the
never-
file and they were both served and the time for them to file an answer has expired. So your motion for default judgment is granted. So. Any other witnesses or any other questions?
That's it.
All right. I do find that the motion for default judgment should be granted. I also find that the proof has been that clear and convincing evidence that the respondents, both the mother and the father, have abandoned the minor children by failing to support the minor children, or the minor child, I guess it is just one, Savannah. When we have 6 or 7 in here, it gets a little confusing. But anyway, they failed to support that child, and they also failed to visit with the child. And both of those are grounds for termination of parental rights. Further, I found that the termination of the parental rights and the establishment of the relationship between the parents, between the petitioners and the minor child as parent and child is in the best interest of the minor child, and that has also been proven by clear and convincing evidence. So those are just technical findings I have to make when it's by default judgment. So anything else?
That's all.
All right. I assume you've got to draw an order and submit it.
I will submit the order.
Well, congratulations to both of you. I admire you for coming back and adopting another child, and I'm sure that child is lucky to have you in the home. And I know that you've pretty much already established the parent-child relationship between you and this child since you've had her since she was a month old. But we're just putting the legal stamp of authority on that. So now she's yours.
Wonderful.
All right.
Thank you.
Congratulations.
Thank you, Your Honor.
You're welcome. All right. Good morning. If you'll raise your right hand, please, to be placed under oath.
Yep.
You are Abigail Knight Addington?
Yep.
Ms. Addington, you filed a petition to change your name. I'm required to ask you a few questions by law. Are you asking to change your name to avoid your just debts or creditors?
Nope.
Are you asking to change your name to avoid criminal prosecution?
Nope.
It looks like your lawyer failed to change your name in your divorce, and you're asking to go back to your prior name of Abigail K. Knight?
Yes.
Is that correct? All right. Have you prepared an order?
I have.
And I'm going to ask you to sign where that X is. Here's, she needs this. And you can sign your new name. So.
Yay. Remember how?
All right. I have signed your final order and changed your name, so you can get a copy of it a little later in the day from the clerk's office, all right?
Thank you so much.
You're welcome. Good morning. If you'll raise your right hand, let me have you placed under oath.
Yes.
Are you Veronica Barreto Duke?
Yes.
Ms. Duke, you are here today on a request to change your name. I'm required to ask you a few questions. Are you asking to change your name to avoid criminal prosecution?
No.
Are you asking to change your name to avoid your just debts or obligations?
No.
So you're just changing, you just want to drop the last surname of Duke, is that correct?
Yes, sir.
And be known as Veronica Barreto?
Yes, sir.
And who are you, sir?
My husband.
Pardon?
I'm her husband.
Okay, so you're here for moral support?
Yeah, pretty much.
Well, normally they would tase you as you came down the hall or down the aisle when you're not connected with the case, but apparently they knew you were a good fellow, so they didn't do that. Have you have an order changing your name?
Yes, sir.
And we'll need to get her to sign off on that. I've drawn a line for you to sign off on that. The reason I do that is just to make sure that there's never any question about the fact that you were here and you actually wanted your name changed. Believe it or not, there might be a few divorce situations where the wife didn't want her name changed and the husband shows up and wants to have his wife's name changed. So I always want to have the person having their name changed sign the order to acknowledge that they are consenting to this.
Yes, sir.
All right. I am granting your name change request, and you can get a copy of it a little later in the morning from the clerk.
Yes, sir. Thank you.
I've prepared an order for Your Honor.
Thank you. Jean Shepherd or Bethany Shepherd? This is a breach of contract action, correct?
Correct, Your Honor.
All right, your motion for default is granted.
Thank you, Your Honor. May I be excused?
You may.
Thank you.
Morning, Your Honor. Here on behalf of petitioner Robbie Lawson on a motion for default. I don't believe there's any opposition this morning.
Right. It was serviced by publication. The time for answer has expired, and you're entitled to a judgment by default.
Thank you, Your Honor. I'll subsequently submit an order.
Thank you.
Thank you.
Mr. Atchison?
Morning, Judge.
Good morning. Are you proceeding on you need your witnesses up?
I do. I have them here, Judge, and yeah, I'll bring them up.
Everyone who's going to testify, raise your right hand and be placed under oath, please.
Yes.
And Your Honor, we're here this morning on a motion for default as it relates to the petition for divorce filed by Ms. Wren against Mr. John Wren. Your Honor, service of process was accomplished in this matter. He was served with the petition for divorce. The 30 days has passed. He's filed no answer. And here he is.
All right, let me deal with this situation. Are you John Allen Wren?
Sir.
Mr. Wren, you were served with a summons for divorce that basically was served on you on September the 23rd on May 14th of 2025. That summons say the following: you are summoned to defend a civil action filed against you in Chancery Court in Dixon County, Tennessee. Your defense must be made within 30 days from the date of this summons is served upon you. You must file your defense with the clerk of the court and send a copy to the plaintiff's attorney at the address listed below. If you fail to defend this action by the above date, judgment by default can be rendered against you for the relief sought in the complaint. And the file does not show that you filed any sort of answer or response, correct?
No, I had a lawyer that didn't file my response. I knew I was gonna go with me. Tell me that's for continuance, and I called his office about 3 or 4 times. No one's answered, no return my call. The answer was no return my call.
Well, he's your wife's lawyer. He's not your lawyer. I understand. Just listen to me. And so as a result of that, he's not obligated to talk to you. However, I will pass this case on the docket, Mr. Atchison, and let you talk to him. What I want you to understand is that because you've not filed an answer, then she's entitled to a default judgment on the grounds of divorce. Then I would have to have a hearing to determine whether or not, what should be done about the divorce, the property that was incurred during the marriage, the debts, and so forth. And that part you can talk with Mr. Atchison if you choose to.
I did that, tried to do that. One person didn't do it, so I fired him.
I'm sorry.
I tried to do that with a lawyer and he didn't file it.
Okay. Well, I understand that. And the only thing I can tell you is that because you've not filed an answer, even pro se, you can file your own answer. But because you haven't done that, then you haven't actually appeared, even though you're physically here, under the rules of procedure. Now, I'm trying to give you now you be quiet when I'm talking. Mr. Atchison, you put on your proof. You can have a seat, Mr. Wren, or you can stand there and behave yourself. If you don't behave yourself, I'm going to have the bailiff escort you from the courtroom. Do you understand that?
If you would state your name for the court, please.
Jessica Wren.
Now, Ms. Wren.
Don't talk to the witnesses. Mr. Wren, don't talk to the witnesses. You step right up. I don't care. You step right over there to the side.
Come over here and sit down. Right there.
Go ahead.
The reason we're here today is you filed a petition for divorce, correct?
Yes.
Within that petition, we established the grounds for this divorce. Is that correct?
Yes.
The grounds that's been established is irreconcilable differences. The fact that your husband, Mr. Wren, has been charged with felony drug offenses in this county, correct?
Yes,
That occurred during the course of the marriage, correct?
yes,
Raise your right. I thought we had placed everybody on.
I thought we did too, Judge.
we did. Yes,
And based on the grounds for this divorce,
You can't get a divorce on irreconcilable differences because it can only be granted on irreconcilable differences if in fact there's an agreement between these parties reduced to writing in a marital dissolution agreement. But she has alleged that the husband is guilty of abusing narcotic or other illegal drugs during the marriage. And she also alleges that he is guilty of inappropriate marital conduct. And she alleges that he has offered such indignities to her person as to render her position intolerable, all of which are statutory grounds. So you need to proceed on those three grounds
Correct.
for your evidence rather than irreconcilable differences.
and Ms. Wren, based on those grounds, you wish to move forward with this matter, correct?
yes.
Now, how long has Mr. Wren been away from the marriage and the marital residence
Fully since May.
of this year?
Yes,
Now, have you been maintaining the payments on the marital residence,
yes,
the general upkeep?
Yes.
The marital residence? And has personal property been divided in this matter?
no,
Okay, Mr. Wren still has property at the residence?
yes,
Now, do you guys have any joint marital debt
no,
other than the residence?
other than the residence, no.
And how long have you guys been married?
23 years.
Now, was the home purchased during the course of the marriage?
Yes,
And you're aware that Mr. Wren currently has criminal charges pending in this county, correct?
yes, I do.
And what do those charges relate to?
Drugs and a weapons charge.
Now, do you guys are the bank accounts separate?
Yes,
There's no minor children
no,
currently in this marriage?
No.
Your children are grown, correct?
grown.
And based on the filings in this matter, you wish to move forward with this default?
I do.
Now, we have your mother and your daughter present, correct?
Yes,
Judge, if I could just ask them some questions.
Step up to the microphone, please.
Would you state your name for the court?
Vicky Parker.
And Ms. Parker, are you the mother of Ms. Wren?
I am.
Ms. Parker, you've heard your daughter's testimony, correct?
Correct.
Now, were you present or have you witnessed the grounds that were set forth as it relates to Mr. Wren's abusing narcotics, illegal drug use during the course of the marriage?
Yes.
And were you also present for the inappropriate marital conduct that's taken place?
I have.
Has there been prior instances of domestic incidents involving Mr. Wren and Ms. Wren?
Yes.
Have there been prior domestic incidents involving Mr. Wren and his children?
Yes.
That's all the questions I have for that witness, Your Honor.
Any reason we have to put this young lady in this situation?
No, Judge, I don't see any reason to.
Corroborating witnesses, in my opinion, I don't think obviously this is an emotional situation for her and I'm not inclined to require her to
And
testify.
I would submit the same.
But if you will step back, ma'am, let me ask these questions. The testimony that I've heard is that there's a marital residence with the debt that she's been paying. But is there any equity in that property?
Judge, there is equity and there is still currently a mortgage. There's about 80,000 that remains on the marital residence that Ms. Wren has been paying and keeping up.
Well, as you know, I'm required, even in a default situation, to make an equitable or fair division. So Mr. Wren needs to be treated fairly regarding that marital property. What are you proposing?
Judge, it would be my position, just like if this matter would have moved forward in a different manner. It was Ms. Wren's understanding as well that the marital residence would be listed and sold, and then the proceeds from that sale would be split between her and Mr. Wren based on the length of the marriage and the fact that it was purchased during the marriage.
All right. Then what about she said, I believe if I understood her correctly, the personal property had not been divided as well.
It has not, Judge. It's my understanding that Mr. Wren still has personal property at the residence. However, there is a matter of Mr. Wren is self-employed, does own his own business. Ms. Wren does not want any part.
What's the name of the business?
W&W Construction.
W&W Construction.
All right. Then anything else of course, you said there's no joint debts between them other than the mortgage.
Correct.
All right, I'm going to order, number one, she is awarded a divorce on the grounds of inappropriate marital conduct. And the default judgment is granted based on the fact that no answer was filed. Secondly, I'm going to order that each of them pay any debts that are incurred in their own name. I order that the marital residence will be listed for sale with a reputable realtor at the price that's recommended by the realtor. Upon both parties will cooperate in signing any listing agreement that might be done. If Mr. Wren for any reason refuses to do that, then I don't know why he would, but if he were to refuse to do that, then under those circumstances, it will be her authority by this court order to sign the listing agreement solely. Once the property has been sold and the closing takes place, the proceeds will be paid into the registry of the court for a division. And at that point in time, both parties will be entitled to a hearing to determine how that should be done. Normally it would be a 50-50 division, but if she's been making the mortgage payments for some time, then we'll go from there. The second thing is his personal property, and that includes his personal possessions and any work-related items that he may have are going to be he's entitled to recover that, but he's going to have a civil standby to go and pick those items up. As soon as that can be arranged by him, he can do that. So, of course, the costs are taxed to Mr. Wren, and we go from there. Mr. Wren, let me tell you something.
I mean, I don't have a lawyer, so I can't say that.
What?
I don't have a lawyer here, so I can't say that.
Oh, sir, you haven't filed an answer to
contest. My house in 23 and a half years.
You have not filed an answer to contest this divorce action, and as a result of that, you've had more than 30 days to file an answer. You haven't done it.
He didn't do what he's supposed to.
And you are teetering on the edge of going to jail for 10 days.
I'm getting everything. I paid every payment for 2 damn months. You're saying she paid all his payments. I've got every receipt. She's paid nothing except
When this house gets sold, then you will have the opportunity to have that done. You'll have the opportunity at a hearing to show what you've paid and ask for any kind of reimbursement for that. Now, you open your mouth again, I'm going to put you in jail for 10 days. That's the judgment of the court. He needs to leave the courtroom. Leave the courtroom.
I've never seen him.
Stay in the courtroom until he has exited the courthouse, and then one of the officers will escort you to your vehicle.
And Judge, just for clarification, would that entitle Ms. Wren to exclusive possession of the residence until this matter is?
Yes. The only provision is that he would be entitled to have
Still
opportunity to recover his items of property. So.
And Judge, I would ask that based on the default, Ms. Wren is asking to be returned to her maiden name, and I will put that in the order as well.
That is granted as well.
Thank you, Judge.
All right.
I get them. Yeah.
I'll let you know when you go.
Thank you.
Call the next case.
Judge, this is just a motion for publication. I represent the petitioners, and we've done an affidavit that set forth that the birth mother or the only respondent's whereabouts have been unknown for some time. The question I have is if your honor's inclined to grant it, where we publish. And as we stated in our affidavit, in July of 2024, she was in Kingston Springs in the DCS case. As recent as April of 2025, she was in Kingston Springs in Humphreys County on a citation. There has been rumor and there has been social media that she could be in Mississippi. I don't find that as
Could
reliable.
be in Mississippi.
Could be. It's like social media post. It's a rumor of a family member, nothing as strong as there's a court order in criminal conduct in Kingston Springs, Tennessee. So we're asking a guest to publish in the Kingston Springs, Tennessee area because that's the last known recorded address with a court. We put everything in the affidavit because we wanted to be frank with the court about what we found everywhere, but I just don't know how reliable the social media posts could be as to her current whereabouts. It is a TPR. We do need to get her notice in the best way possible. So that's where we are, is if you're inclined to publish, where we publish.
So this Facebook posting in Mississippi missing persons alert saying that she's been missing for over 2 weeks and 5 months pregnant, asking, there's no other information that you have about that?
No, sir. And when we go back to click on that now, it's gone. So it's like it was there and then it's been taken down. So I don't know how reliable that is or is not. Twitter says she may live there. When we check VineLink, even as recent as this morning, she is not incarcerated in Tennessee or Mississippi. So.
All right, well, your affidavit of reasonable efforts, I think, has been met, so I will grant your request for a motion by publication.
Okay. And do you
of
feel that,
Service by publication.
okay, and do you feel Kingston Springs is the appropriate place to publish with the last known
I
court
think so.
recorded?
Do we have to use two now?
We do. It's if there's a secondary publication, we're supposed to find it at a website, but I don't know if Humphreys County has one.
Dixon Post is the one that's usually used here.
Okay.
So if you got the Dixon Post and what is the Kingston Springs paper?
Yes, sir. I think so.
What's the name of it?
It's, well, I don't know what the name of that. I hadn't prepared the order because of this new law.
All right.
We're supposed to, if there's a secondary source online free for somebody who's supposed to do it, if there is one, but I don't know if every county has one. Okay. All right. We'll contact the Dixon Post and follow whatever we're like, that or Humphreys County. So whatever service both. Thank you, Judge.
All right, this is a show cause on the failure of either party to comply with the rules of the parenting plan's provisions of attending, showing proof of completion of a parenting class. So the court's going to enter an order that reflects that neither of them is in compliance with that court order. The significance of that is that if there's future litigation, then the fact that they failed to attend and complete a parenting class can be considered by the court on the issue of custody. All right, call the next case. Motion for an order of reference to a special master. Motion is stricken for failure to prosecute.
Honor.
Good morning.
Can I represent the estate in this matter? I have with me here today the realtor who listed the property, Miss Michelle Johnstone, and the executor of this estate.
I have some
Mr. Jim.
experience with Ms. Johnstone, so
Yes.
All
raise
right.
your right hand. Let's place you both under oath. She helped me with the sale of my home, if I recall correctly, so. I
Thank
just
you very
make that a public knowledge so that it was, when I said that, it came out the wrong way. I wanted to make it clear, so. Go ahead.
I trust that was a positive experience. So,
And I will say this, you do understand that, I know you've grown a mustache.
yes, Your Honor.
Looks very handsome. But
Thank you, Your Honor.
You do understand that Stephen Colbert grew a mustache while on vacation and ended up having a show canceled as a result.
Well, yeah.
Right.
I'll say for the benefit of anybody watching online this morning, this started out as a joke. I came out of the bathroom with this on my face and my children said, "Oh my God." And I said, "Well, it has to stay now." So it started out messing with my children. So they don't like it. So that means it's here for a little while.
All right.
So,
I apologize for intruding into your
yes,
presentation.
Mr. Stewart, would you please state your name for the court?
Gene Barrett Stewart.
And Mr. Stewart, you are the executor of the estate of Miss Nancy Carroll Taylor, correct?
Yes, I am.
And to that end, you were authorized by the power of her will, the appointment, to list her property for sale.
That is correct.
And to that end, did you list that property for sale?
Yes, I did with Michelle Johnstone.
And as part of that, did you all discuss what the purchase price ought to be or the listing price?
Yes, we did.
And was that property indeed listed?
What's that?
Was it listed for sale?
Yes, it was.
And do you recall how long or when it was first listed?
I believe we listed it probably, I think it was in May. I mean, I may be,
Okay.
yeah.
And did you receive an offer on the property?
Yes, we did.
And how much was that offer?
It was $299.
Okay. And did you discuss that offer with Ms. Johnstone?
Yes, I did.
And did you all decide, based on her knowledge and experience and your desire, that was a good purchase price?
Yes, I did.
Okay. And also, as part of that contract, are there certain repairs that are going to have to be done to the property?
Yes, sir.
And were those part of the negotiations?
Yes.
And will you explain to the court just how those are going to be accomplished, those repairs?
So some of the repairs we've already taken care of, like my handyman has, done most of them. And we've already paid him for that. But there's also the pipe that goes underneath the I guess the yard and stuff like that is what is it?
Cast iron?
Yeah, cast iron. And they want that replaced, just based upon not the administrator, but the, searching for the word here.
The purchaser?
Yes, correct. Yeah.
And so you have discussed with Hiller those improvements?
Yes, I have.
And they have provided what that's going to cost?
Correct.
And those will be done after the closing, at the cost of the estate, correct?
Yes.
And it was done that way so that the purchaser can enjoy the benefit of the warranty of that work that Hiller's going to do, correct?
Correct.
And how much were those repairs?
I think it was $87.47.
$8,700?
Yes, sir.
Okay. And you want the court to approve this contract?
Yes, I do.
Okay. And we've provided notice to everyone?
Yes, we have.
Okay. Ms. Johnstone, would you step up here? Please state your name for the court.
Michelle Johnstone.
You are a licensed realtor, knowledgeable and experienced in not only Dixon County, but especially in Dixon County. Is that correct?
Yes, 30 years.
And you were listed or contracted to sell this property for
Yes.
Mr. Stewart, is that correct?
Yes.
And you looked at comps in the area and came up with a listing price, is that correct?
Correct. Yes.
And listed the property just like you would any property?
Yes.
And received this offer, is that correct?
Yes, we had a previous offer that fell through, and then this offer came in and we accepted it.
And this offer that's been made on this property, how does it line up with the comps?
The comps actually came in slightly under what we contracted the property for. So, it's worked out nice for the estate.
Okay.
And the appraisal actually was waived on this, so it is moving forward. Of course, it's not a done deal until everybody signs off, so.
But this is a contract that you recommended your seller to
Absolutely,
accept.
absolutely, yes.
You think it's reasonable and fair and ought to be accepted, and I would ask the court
Yes, I
to
do.
likewise approve it.
Yes.
That's all I had. Rich.
All right, Ms. Johnson, you believe this to be a fair price for this property?
Yes.
All right, I'll be glad to approve your contract for the sale then.
Okay, thank you.
Thank you.
I'll pass this order up, Your
Yeah.
Honor. Get you guys copies.
Good morning.
Morning.
Are you Jaroslav Kosurik?
Yes, sir. Yes, Your Honor.
And is your wife Sydney Cheyenne Kosurik, is she not here?
She is not here, no, sir.
Any reason why she's not here?
She texted me this morning saying she didn't feel good.
Okay. This is a